This was fresh admission into week commencing 4/5/2026. Yes, next please.
Items
This was fresh admission into week commencing 4/5/2026. Yes, next please.
items
This was fresh admission into week commencing 4/5/2026. Yes, next please.
items
Petitioner of
Today the matter being in
This was fresh admission into week commencing 4/5/2026. Yes, next please.
items
petitioner of seeking adjournment. Today the matter being in
This was fresh admission into week commencing 4/5/2026. Yes, next please.
items
petitioner of seeking adjournment. Today the matter being in
This was fresh admission into week commencing 4/5/2026. Yes, next please.
items
petitioner of seeking adjournment. Today the matter being in
This was fresh admission into week commencing 4/5/2026. Yes, next please.
items
petitioner of seeking adjournment. Today the matter being in
This was fresh admission into week commencing 4/5/2026. Yes, next please.
items
petitioner of seeking
Who is Baisi?
21 22 both.
Who is Baisi? We commencing 11/5?
Item 26.
Just. Page 5, 24 to 28.
26.
Item 16, my lord.
16 upon fill or miss kari.
On behalf of Mr. Sharma and on behalf of short attendance. We have filed the rejoinder.
16 state is the OP. Okay.
Mr.
अच्छा. Adjournment चाहते कि?
Yes.
16 date करो तो.
We can say 11.
Item 26, my lord.
26.
We have to file counter affidavit in this case.
Not filed.
That is prepared.
Not yet.
Will be filed within a
26
week
date कर दियो.
We can say
of last.
Item 27.
27.
27 is fixed for 2 p.m. but since court is not functioning at the post.
So I will take that up. If he comes up, that is providence.
Yes, ma'am. In that matter, my lord has directed me to file an application.
Yes, that admission has taken place.
It has been taken place.
So at least I mean some sort of solace or what you call some peace is there. I mean children's admission, the way
It's
the
been
parents are behaving is interesting.
Your Lordship, item number 10,
Okay, don't sir. ଆପଣ ଫେର ପଛକୁ ପଳେଇଲେ don't wind it up. I mean rewind. 27 ଗଲା. ଦେଖିବା ଯଦି ଆସିବେ ତାହେଲେ ଦିଟା ବେଳେ ଟେକ୍ ଅପ୍ କରିବେ ନା ତାଙ୍କୁ ଇନଫର୍ମ କରିପାରିବ ହବ ସେ ଆସିବେନି ବୋଲି ଯେତେବେଳେ ଛାଡି ଦିଅନ୍ତୁ ଇନ ପର୍ସନ ସେ ଆସିବେ ଟେକ୍ ଅପ୍ ସେଟା ଖାଲି ଦିଟା ବେଳେ ରଖିବେ
Affidavit court has directed me, but register it is not accepting since I could not serve the copy of that affidavit as he is not there.
ଆଜି ସର୍ଭ କରିଦେବେ
Aji serve.
ଆଜି ସର୍ଭ କରିଦେବେ ଆପଣଙ୍କ ବର୍ତ୍ତମାନ ଇସ୍ୟୁ ହେଲା ଯେ ସେ ଆଡମିସନ କେମିତି ହବ
Admission has been done in school.
ସେ ପିଲା ଯାଉଛି
school.
ଛୁଆ ସ୍କୁଲକୁ ଯାଉଛି
Again, with photo, I have
କିଏ ଯାଉଛନ୍ତି ତ ଛାଡିବା ପାଇଁ
the school bus.
ବସ୍ ଏତେ ଛୋଟ ପିଲା ଯାଉଛନ୍ତି ଆଲାଉ କରୁଛନ୍ତି
Again,
ଆପଣ ମାନେ 2 ଜଣ ଯାଉନାହାନ୍ତି
can go.
ନା ସ୍କୁଲରେ ପହଞ୍ଚି ପାରିବେନି ବେଟର ସେ ବସ୍ ରେ ଯାଉ ଆପଣ ମାନେ ବସ୍ ପଛେ ପଛେ ଯାଇପାରିବେ କାରଣ अर्लियर 22-23 वर्ष तले छोट पिला बस से अलाउ करना नहीं जीवा पड़ता ठीक अच्छे सो फार सो गुड बट आई थिंक आई मीन दे हैव ए फ्यूचर आई मीन ऑल एवरीथिंग इज फाइन समथिंग मे बी हैज गॉन रॉन्ग बट some issues are there.
And since on the last date there is an order to go to take the child to park. So as soon as the child gets down off the bus, the father takes him to the park and plays with him for 2 to 3 hours. So I think the order of this.
Sir, any father playing with a child in the park,
but that speech therapy class is at 6:30. He knows that very well, but does not bring and
speech therapy gradually he will pick up. Speech therapy कोट रे जाउछ को क्लास
घरे सीडी जाय टीचर
याकर जगन्नाथ प्रसाद दास कर ओडे थिला लीडिंग साइकोलॉजिस्ट ऑफ ओडिशा चाइल्ड साइकोलॉजी हैज डन सेमिनल वर्क ताकर यंगर ब्रदर इज जगन्नाथ प्रसाद फेमस कार्डियोलॉजिस्ट सो सेटा थिला he shifted. So Canada re both he on lot of fame in Canada. He worked there. Then he returned to Bhubaneswar. तापरे से आरंभ करथिले सेटा. Total parts रे खेलियो कि speech therapy that is now the controversy. ठीक है. Page 6 item 2930. आपको 10 कौन बोल रहे सर?
Your Lordship, the counsel for the petitioner cannot appear as his mother-in-law passed away. So kindly grant adjournment for a week.
When did she pass away for the last time?
No, sir.
Usually
recently
mother-in-laws pass away every day, especially
No,
for
sir.
mothers.
No, sir. Actually,
Mother-in-laws, they go on passing away.
no, sir. Actually,
Conveniently, they pass away.
sir, 3 days back.
No, hopefully that is for the last time she passes away.
Item 11 you lost. Item 11 you lost.
Just one, sir. Just one. Upon Rundu,
Sure, Your Lord.
are you married?
No, sir.
Oh. So you don't have that advantage. Now CPC, I think that it would incorporate that because the learned counsel is busy in another court shall not be a ground. After amendment, it is there.
No, sir. He is not busy in
Passing
another.
away mother-in-law shall not be a ground. I think that will be incorporated. The matter has been adjourned on behalf of the petitioner by his learned counsel on 12/8/2025, on 30/10/2025. On 22/01/2026, none appeared for the petitioner. 22/01/2026, 22/1/26, तापर लिखिबे 27/2/26, 22/1/26, 27/2/26, 19/3/26. On 19/3/26, the registry was requested to intimate the learned counsel for the petitioner. Though the intimation has yielded result, as upon Ganata, sir,
Ashutosh Devata.
power achi.
Yes, no, sir.
Mr. Ashutosh Devata appears on behalf of J.M. Patnaik,
Yes.
on behalf of the learned counsel for the petitioner, Mr. Patnaik. Mr. Devata seeks adjournment on behalf of the learned counsel for the petitioner due to bereavement in the family. Stop. Other side will inform Kochandi. Please have the courtesy of informing the other side. They will be expecting the orders matter to reach. Matter shall be listed for orders in the week commencing 4/5/2026.
Thank you.
Yes.
Item number 11 you lost. Item
11.
yes.
Yes.
Yes, old matter, I have no contact with the partner. Advocates which will not see. Long
Yes,
things
sir. No, you are appealing for the petitioner,
for the petitioner also lost.
Mr. S.K. Panda.
Devadatta,
Mr. Devdutkar, you filed your memo.
man. I'll
कागज तो दियो. नोटिस तो अपोजिट पार्टी को तो दिया है नॉन फाइलिंग ऑफ रिक्विजिट से कि रही गोटे
फर्स्ट टाइम जाइतला सेकंड टाइम डिफॉल्ट
बर्तमान नो इंस्ट्रक्शन
वर्तमान मंच
आइटम नंबर टा पकेगी मेमोटा दे दियो
मैन
कॉल करो तो
Item 1.
On behalf of Prakash.
Again?
On behalf of Prakash Behra. Pilot kindly mediation.
Sorry, kindly take a little bit louder. अपन से microphone down अच्छी.
Hello.
कौन कौन कहले?
I am on behalf of Prakash Behra. Kindly send the mediation.
Mediation कौन है?
ଯାହା କହିଲେ ଏଇଟା ମୁଁ କଣ
mediation ତ କଣ ହେଇପାରିବ? According to you, what mediation can be done?
ମତେ ଯାହା କହିଥିଲେ ଜିନିଷ
ବୁଝିବେ ନା ଆଉ ସେମିତି ବେଳେବେଳେ ଆପଣ ଭାବିବେ ଯେ ବୋଧେ କୋର୍ଟ କିଛି ବୁଝିପାରିବେନି କି ରିଆକ୍ଟ କରିବେନି, ବଟ୍ ସେଇଟା ବି ଆପଣ ପ୍ରିପେୟାର ହେବେ ନା ଯେ କୋର୍ଟ ପଚାରିବେ ବୋଲି ଏଇଟା ମେଡିଏସନ କଣ ହବ, ଆପଣ କଣ ଇନଷ୍ଟ୍ରକ୍ସନ ଅଛି. Must understand the mediator cannot, direct the parties to appear and all these things. What is your instruction? And the mediation order has to be some structured order. କେବେ ଇନଷ୍ଟ୍ରକ୍ସନ ନିଅନ୍ତୁ.
ଇନଷ୍ଟ୍ରକ୍ସନ
ହେଁ?
ଆଣିଛି ସେ କହିଲେ ମେଡିସିନ
ସେ ପ୍ରକାଶ ବେହେରା ଆପଣଙ୍କୁ କହିଲେ, ଆପଣ ବର୍ତ୍ତମାନ ମୋର ଆପଣଙ୍କର ନାଁ କଣ?
ଶ୍ରୀକାନ୍ତ କୁମାର ବାରି
ଶ୍ରୀକାନ୍ତ ବେହେରା, ପ୍ରକାଶ ବେହେରା ଭିତରେ ମୁଁ ବର୍ତ୍ତମାନ ମିଡିଏଟର. ଆପଣ ସେ କଣ ଆପଣ ଇନଷ୍ଟ୍ରକ୍ସନ ଦେଲେ, କଣ କହିଲେ ବର୍ତ୍ତମାନ ମତେ ମିଡିଏସନ କରିବାକୁ ପଡିବ. ମିଷ୍ଟର ସାହୁ କଣ ମିଡିଏସନ କଣ କରିବେ?
Mediation respondent number 3 has expired on 27/10/20. Respondent number 4 has expired.
ସେଠି ଅଛନ୍ତି ସାହାପୁରରେ ସିଏ ତ ମିଡିଏସନ ଆସିବ
କାହାକୁ ନେଇକିରି କରିବେ? ସବୁ ମରିଗଲେ.
ଇନଷ୍ଟ୍ରକ୍ସନ ଆଣି
I knew this Mr. Sahoo is keeping close to his chest. କୋଉଠୁ ଇନଷ୍ଟ୍ରକ୍ସନ ଆଣିବେ ସାର୍? ସ୍ୱର୍ଗ କି କୋଉଠି ଥିବେ ତ ସେ, କେମିତି କଣ କରିବେ? ଆଟଲିଷ୍ଟ ଜାଣିବେ ତ ସେ କୁଆଡେ ଗଲେଣି, କଣ ଅଛନ୍ତି. ଆପଣ 15 ମସିହାରେ କେସ୍ 10 ବର୍ଷ 11 ବର୍ଷ ପରେ Mr. Ashok Kumar Behra, on behalf of PR Behra for the petitioner. Mr. Prem Kumar Mahanti. Mr. Mahanti, you are there? Yes, ma'am. Prem Kumar Mahanti, Additional Standing Counsel for the OP number 1 and 2. गोकुल गुंडा भी चलिए
ମାଇଲର ସେ ଚାଲି ଯାଇଛି.
ଆପଣ ଗୋକୁଳ ଗଣ୍ଡାଙ୍କର କିଟା କେସ୍ ଆପଣଙ୍କର?
ସେ ଗୋକୁଲ ଗଣ୍ଡାର ମୁଁ ନଥିଲି, ମୁଁ ସେଇଥିରେ ଗୋକୁଲ ଗଣ୍ଡା ହେଡ୍ ଫାଇଲ୍ଡ
ଗୋକୁଳ ଗଣ୍ଡା ଆପେଲେଣ୍ଟ, ଆପଣ ଥିଲେ
ମୁଁ ଥିଲି
ରେସ୍ପଣ୍ଡେଣ୍ଟ.
ରେସ୍ପଣ୍ଡେଣ୍ଟ. ସେଇଥିରେ
ଭଲ ତ, ଆପଣ ଗୋକୁଳ ଗଣ୍ଡା ଗୋଟେ କେସ୍ ବଢିଆ ଚାଲିଛି ଆପଣଙ୍କର.
ଗୋକୁଲ ଗଣ୍ଡା ପାଇଁ ମୁଁ ନୁହଁ, ମୁଁ ସେ ମନ୍ଦାର
ଆପଣ ତ ସିନା ଅନ୍ୟମାନଙ୍କୁ ପାର୍ଟି କଲେ ଆପଣ ଆପିୟର କରୁଛନ୍ତି. ଯଦି ଗୋକୁଳ ଗଣ୍ଡା କାହାକୁ ପାର୍ଟି କରନ୍ତେନି, ଏଇଟା କଣ ସେଇ ସେମ୍ ଲ୍ୟାଣ୍ଡ ଆକ୍ୱିଜିସନ?
ସେଇଟା arising out of same land acquisition reference case.
The earlier judgment in Gokul Gonda will not has no impact on this. Examine କରନ୍ତୁ.
Impact କରିବ.
ଗଣ୍ଡା ନା ଗଣ୍ଡ କହୁଛନ୍ତି?
ଗଣ୍ଡା. କାହିଁକି ସେଇଥିରେ ଗୋକୁଲ ଗଣ୍ଡା had filed the land acquisition appeal stating that he is the son of one
ଏଥିରେ ବୋଧେ ଗୋକୁଲ ଗଣ୍ଡାଙ୍କର ନିଜ ଜମିର ଯୋଉଟା ତାଙ୍କ ବାପାଙ୍କ ଜମି ଏଇଟା।
ନାଇଁ, ଗୋକୁଲ ଗଣ୍ଡା ସେ କହିଲେ ଯେ ମୋ ବାପା, ଏଇ କେସରେ ଗୋକୁଲ ଗଣ୍ଡାର କିଛି ନା କରିବାର ନାହିଁ।
OP3 ହେଇଛନ୍ତି
ଯେହେତୁ ସେ ପାର୍ଟି ଥିଲେ ଲ୍ୟାଣ୍ଡ ଆକ୍ୱିଜିସନ ରିଫରେନ୍ସ କେସରେ, ଦ୍ୟାଟ୍ ଇଜ ହ୍ୱାଇ ହି ହାଜ ମେଡ୍ ଗୋକୁଲ ଗଣ୍ଡା as party ମାଇଲର. In the land acquisition reference case, ଗୋକୁଲ ଗଣ୍ଡା was arraigned as respondent ମାଇଲର.
Adjournment shortfall লিখଛନ୍ତି Mr. AK Behra, Lorded Counsel, appearance ତାପରେ ଆପଣ Mr. ସାହୁ କାହା ପାଇଁ?
ମୁଁ ପାଇଁ ରେସ୍ପଣ୍ଡେଣ୍ଟ ନମ୍ବର 4 ପାଇଁ
Mr. GN Sahu for OP number 4.
My request, my request, my senior's name is
Mr. AK Nanda.
My
Mr. AK Nanda along with Mr. GN Sahu for R4. Pursuant to the order dated 26/3/2026, the registry has intimated the learned counsel for the appellant the adjournment is sought for on behalf of the learned counsel for the appellant Mr. PR Behra by the learned counsel Mr. A Behra.
नहीं, SK Barik.
Mr. SK Barik, sorry.
SK Barik.
Mr. S.K. Barik. The learned counsel for the appellant shall obtain instruction and take steps if so advised regarding substitution of ki chali galani, Mr. Sir?
Respondent number 3 and respondent number 4.
Regarding substitution of R3 and R4 who are stated to have passed away during pendency of the appeal. Stop. Kebe asile habo? The matter shall be listed under the same heading in the week commencing.
Next week.
Next week आपण instruction and परिवे तो आसुनांती बोल तो पढ़ी 11 वर्ष है
2 weeks.
list in the week commencing 4-5 है
4.
जो माने ताको रिप्रेजेंट करूछंती ताका सारे जदी कथा ही परिवे आपणकर जदी मिस्टर साहू यू कैन टेक इंस्ट्रक्शन ऑल अगेन सब्स्टिट्यूशन पे पढ़ी के रहला फिर
से सब्स्टिट्यूशन कले तो मु कोनी अपियर करिवि से करू नांती सब्स्टिट्यूशन ताको लास्ट चांस दे देले से कम इंस्ट्रक्शन
कौन देबी मु तो 11 वर्ष हैला
तीनटा डेट लाणी एमपी रे भी से माने अपियर करना
देखंतु पैटटा को
आगे, आगे।
पकई रखंतु नि
नहीं नहीं 4-5 रो डिस्कशन कर
आपण जे अपोर्शनमेंट पे एग्री करि परिबे सो दैट आपण जदी कहिबे ताके सारे कथा हेबे अपोर्शनमेंट हेले एसी पैसा पाइबे यू कैन टॉक टू मिस्टर साहू अब जदी से माने केही नहंती से लैंड एक्विजिशन मैटर रे गोटे केस रे the person who is claiming to be a descendant or a legal heir is no way connected. So that is a very hard case where mediation or any kind of intervention will not work out.
they are related.
This could be. This appears because all are respondents.
Smile. They are related.
देखो आपण भी बुझंतु जे अपोर्शनमेंट ता वर्कआउट हे परिबो मेडिएशन आपण निजे कर परिबे
प्राय से माने भी निजे कॉन्टेस्ट करथिले सो 5-6 भौणी the respondent number 4 and all the appellants are sisters, my lord. They have contested the land acquisition reference and they themselves have admitted that the will number registered by the petitioner's mother in favor of a respondent number 4. They have not denied that, my lord. That is also reflected in the order itself, my lord.
सेठी will probate दरकार नहीं
Probate स्थिति दरकार नहीं सुंदरगढ़ रे में से माने भी किछि भी ऑब्जेक्शन करनांते से will the attention finality they have not challenged against that anybody.
उल्टा परे जेबे भी चैलेंज ताका नोटिस को जेबे आसो चैलेंज करि परिबे
My lord.
से तो जानि नांदी कहउचंती एबे किछि सोगी भी लाभ नहीं एनीवे ठीक अछि ठीक कथा हुन
कथा
yes next
Item 2.
May I please, Your Lordship? My Lord, I'm appealing for the petitioner, Your Lordship.
your name sir
My Lord, Saswat Kumar Sethi.
Mr. Saswat SK Sethi were
My lord.
SK Sethi on behalf of A Tripathi for the petitioner. Yes, please.
My Lord, the impugned order dated 3/8/2022 passed by the learned judge family court Nayagad is under challenge in this argument, my Lordship.
Yes.
My Lord, the opposite parties who are the wife and the daughter had initially filed an application under section 125 CRPC claiming maintenance of 8,000 rupees, Your Lordship.
Yes.
And Your Lordship, this and the learned judge family court by order dated 3/8/22 had passed the order by awarding maintenance of 3,000 rupees to the opposite party number 1, who is the wife, and 1,500 rupees to the opposite party number 2, who is the daughter, Your Lordship. Of every succeeding month from the date of application, that is.
For 22 रे 4 वर्ष हैला what is the status of the case execution हेची
सेटा 17 ରୁ 22 जाए केसटा पेंडिंग थिला, Your Lordship. अब जे सेतरे ସେମାନେ इंट्री में एप्लीकेशन फाइल कर नथिले जो अवार्ड मेंटेनेंस अवार्ड मेंटेनेंस हेई थाता
डिफेक्ट रिमूवल हे गेला एथरे
माय लॉर्ड इट
अच्छा
but notice as may I pray, Your Lordship, if notice may be issued to the
no notice not at the invitation notice or invitation to be sent
But,
vote cannot be converted it's a post office like I'll invite everyone whoever files a case whether you have paid anything or what is the status
but from 2017 to
what is the judgment on this which are the judgments
well, the matter
Supreme Court decisions are directly covering this the 125 CRPC you want interference in the decree, you have to deposit the entire amount.
But my lord, the matter continued for pending till 2000, from 2017 to 2022.
That you don't have to tell a judge 3 times to understand.
And they never filed an IA for directing, for the.
No, have you complied with the decree?
No, my lord.
So don't find fault with the other side when you yourself do not comply with the decree. And the pretext of the pendency of this petition, you are not paying. Who has stayed the order? Which court has stayed the order?
My lord, Learned Judge, Family Court, Nagpur.
You have stayed the order.
No, you'll, I'm praying, when I have filed an IA.
The decree you are, the award you are 125 order, who has stayed that order? It has not been stayed.
Not been.
Then you have frustrated it. Court will not be aiding your non-compliance of the award, maintenance award. It is highly deprecated by Supreme Court. What he does?
My lord, is a daily laborer, your lordship.
Very well. Now it is 600 rupees. You answer 18,000.
I did want
40% is 9,000, 8,000. So it is good. Have you seen his marriage video? See that. You'll realize that whether he's a daily laborer or not.
My lord, in fact, both the petitioner and opposite party were in love relation with each other, your lordship. It's a love marriage, your lordship.
Any exception in 125 in case of love marriage? 125 is not maintainable. Please we are being watched by the world. A lawyer submitting before a court, the petitioner is not paying, daily labor is not tenable ground. But love marriage is a ground in 125 proviso. You must understand that we are discussing law. It should be legally nuanced.
Man.
I may like he not paying, but that even me liking also, I cannot do anything. Let us assume that because it's a love marriage, so he let him not pay. But I can't be guided by those kind of notions or perception.
But in fact, the wife.
You are officer of the court. I am sitting as I have to adjudicate,
Man.
and it has to be legally nuanced. The discussion has to be legally nuanced.
My lord, in fact, the
Whether
wife.
they started, they were in love or so. These kind of petitions are actually this jurisdiction in RPFM has completely lost its way. In almost all the cases, they are filing RPFM and the matter is kept pending and nothing is paid. The problem is there is no incentive for the petitioner because he is happy. He doesn't wish to pay, and the court becomes knowingly or unknowingly party to the entire thing. The learned counsel for the petitioner is, have you examined what is the scope of revision by this court? That also you have to, whenever you appear and hold a brief for fresh admission, please look into the law. That is the difference between the legal discussion and common room discussion.
Yes.
Please appreciate that.
Man.
And somehow this, not reading becomes also a habit. Reading is a habit. Not reading and saying anything and everything in court, because maybe what you are saying, it's nothing wrong there. But whether those are legally tenable, the court should consider those things. That is important. The learned counsel for the petitioner is had at some length. The petition was presented before this court on 26/10/2022. Defects were pointed out at a staff report dated 10/11/2022. 10/11/2022. Stop. The defects were not removed. The matter was taken up by the Deputy Minister Judicial, into bracket Judicial, then comma Logima. by order dated taken up by so and so Lajima on 21/11/2025. Stop. 3 weeks time was granted for removal of defects. Thereafter, stop kari. Thereafter, comma, the matter was listed before this court on 16/3/2026. Further 7 days time was granted for removal of defect. Stop. After removal of defects, the matter is listed. After about 4 years for fresh admission. Stop. The petitioner, husband in the marriage, is before this court, challenging the order passed by the Learned Judge Family Court Noyagarh in CRL.M.P. number 284 of 2017. Judgment date pakde nahi. Judgment dated 03.08.20222. Stop. By the said judgment, the application filed by the wife in the marriage, then is it about 23 years, and the minor daughter born from the wedlock, then is it about 2 years. Under section 125 of CRPC, into bracket, insipid and substituted by parimateria provision, comma, section 144 PNSS 2023, bracket closed, was allowed. The wife claimed 6,000 maintained per month. The wife claimed 6,000 rupees as maintenance for her and 2,000 for the minor child to get rid of vagrancy and destitution. The Learned Judge Family Court adjudicated the matter based upon the evidence rendered by the claimant opposite party wife, the petitioner, not claimant, petitioner opposite party wife as PW1, her father as PW2, the present petitioner examined himself as OPW1 and co-villager as OPW2. The evidence on record regarding earning of the present petitioner figure, that is rupees 20,000 per month, and agricultural income the total income coming to rupees 3 lakh for annum. Remained unrebutted. So, however, the Learned Judge Family Court directed rupees 3,000 per month for the wife and rupees 1,500 per month for the child from the date of application, that is 27.11.2017. Full stop है ना? 27,11,17 ना 23,11,17 On instruction received, the learned counsel for the petitioner submits that no amount has been paid by the petitioner during the pendency of the petition before the learned family court or as per the judgment and order dated 8/2022. The total amount due comes to till 27 11 no 27 এটা কোন মাস এপ্রিল 27/3/2026 comes to 99 months for 99 months comes to 4,500 99 4,50,000 4,500 କଟିଯିବ It is submitted by the learned counsel for the petitioner that the petitioner is a daily wager. Though apparently no such evidence has been adduced before the learned judge family court. The scope and implications of section 125 CRPC has been elaborately dealt with by the Honorable Supreme Court in the decisions Samima Faruqi, তারপর লিখবে কমা citation দেবে তারপর দেবে Rajneesh versus Sneha. The relevant paragraphs from the said two decisions are reproduced here. The concept of the husband, the plea of the usual plea of husband denying to pay any amount have also been dealt with in Samima Faruqi. Stop. For sustaining the challenge, the petitioner, if so advised, shall file affidavit indicating how he will secure the amount of rupees 4,50,000 minus 4,500. Stop. Whatever. কেবে আসলে হবে?
Valid any date after 3 weeks.
List in the matter shall be listed for fresh admission in the week commencing 4/5/2026. And that, in fact, Mr. Sethi, in fact, that is the difficult part of this profession. You have to talk straight on the face to your client. You have the greatest advantage. এটা বন্ধ করো।
And lastly, instruction previously directed to instruction.
Your name, sir? So,
SK
Barik for
SK Barik, Srikant Kumar Barik. ଏଇଟା mediation କୁ ଯାଉ settle ହେଇଯିବ କଥାବାର୍ତ୍ତା ହଉ।
ଦେବେ।
ଓ-
ପଇସା ଦେଲେ mediation। ମୁଁ ପଇସା ଦେଇପାରିବି। I have no authority to mediate for a decree.
notice
Last order শুনলে এতে elaborate discussion হবে। Notice जाओ माने कौन? Personal लेखा.
ନାଇଁ
What is this submission notice जाओ?
notice.
Who provision है अच्छी notice जाओ?
Direct
High Court is meant for issuing notice. No, please don't take it. It's a serious legal discussion. Academic. High Court is here to issue notice, whoever comes.
pattern to notice.
That's the law. There could be, you must examine. I mean, you should be always serious that suppose notice is the High Court or Kamala notice issue karo. That is the law, then could it be? What is the difficulty?
Let's see. Kindly say some
The matter
something.
was heard at length on 21/6.
ସିଏ ସବୁ ଚାରି ପାଞ୍ଚଟା କେସ୍।
The learned counsel for the petitioner had adjournment to address the court regarding the jurisdiction of this court under section 19(4) of the Family Courts Act, and also the revisional jurisdiction. Again, the matter was taken up on 13/3/2026. When another learned counsel sought for adjournment and the matter was adjourned. Today, learned counsel Mr. Parikh submits that notice same issue. In considered opinion of this court for exercising jurisdiction, the section 19(4) of the Family Courts Act, with the revisional jurisdiction. This court has to be prima facie satisfied that case is laid out for issuance of notice. Looking at the material available on record, that is the judgment of the learned judge family court. The revision arises, the present revision is a challenge to the judgment dated 13/11/2025. You take, you should have take some time in dictation. 13/11/2025 passed by the learned judge family court Hon'Ble. In criminal proceeding number 20/2024. Criminal proceeding number 20/2024. The same proceeding was initiated by the wife in the marriage. They resident about 31 years. Under section 125 of CRPC. Seeking monthly maintenance. The petitioner wife and the opposite party husband got married on Ekar P. Pune case at Hon'Ble. Stating that to prevent restitution and vagrancy, it requires rupees 30,000 per month. The present petitioner filed his appearance and contested the matter by filing written statement. The claimant wife examined herself as OPW1 and her father as PW1. OPW. The claimant wife examined herself as PW1. And the opposite party examined himself as OPW1. So the father of the opposite party, present petitioner husband, also deposed as OPW2. The Lord Judge Family Court has dealt with the provision of the ingredients, the essential ingredients of section 125 CRPC. So the opposite party husband contended that the petitioner wife was earning, but did not adduce any evidence. So it was further. The further finding of fact by the Lord Judge Family Court is that the petitioner used to work when she was with her husband. And after she left the matrimonial house, she has stopped working. And she had filed a proceeding under section 13 of the Hindu Marriage Act. 13 filed a proceeding seeking divorce. The husband was directed to pay 15,000 as maintenance per month of the date of application, that is supposed to put 2026. Which he did not. Stop. Till the counsel to the petitioner for instruction submits that the petitioner has not paid any amount towards maintenance or maintenance. The opposite party wife. Stop. Till from 24 to 24 till 24 to 24. 24 करते हैं 24 For 25 months, the amount due comes to repeat करो. The matter shall be listed for fresh admission. Yes. Differentiate করতে তাহলে ওটা ডেভেলপ হতে লট ওরা খালি কହୁଛନ୍ତି পাইলট বিল শুরু ওরা আগে লট বলি কিছু নাই শুনতে ଆପଣ କହୁଛନ୍ତି ଗୋଟେ କଥା ଆପଣ ଜାଣି ଦେଲେ ଚଳିବ ମୁଁ କେସ୍ ଯଦି ମୁଁ କିଛି ଆପଣ ଗୋଟେ କଣ ସାଇଟେସନ ଦେଖାନ୍ତେ କି ପ୍ରୋଭିଜନ ଅଛି
ନାଇଁ ସିଏ ସବୁ କରିଛନ୍ତି ଆମର ପ୍ରଥମେ
ଡିଜିଟାଲ ଜୁରିସଡିକ୍ସନ ରେ ଆପଣ ଗୋଟେ ଜଜମେଣ୍ଟ ଆଗେ ଏକ୍ସାମିନ କରିବେ
ନାଇଁ ଆମର ସିଏ ସବୁ କରିଛନ୍ତି ପ୍ରଥମେ ଇସ୍ୟୁ ନୋଟିସ କଲେ ତାପରେ ସେକ୍ସନ 9 ରେ ଫାଇଲ କଲେ ସେଇଟା ୱିଡ୍ର କରିଦେଲେ ଡିଭୋର୍ସ ଫାଇଲ କଲେ ଆମେ କିଛି ଗୋଟେ କେସ୍ ଫାଇଲ କଲୁ
ରେ ଆର୍ଗ୍ୟୁ କରୁଛନ୍ତି ମେଣ୍ଟେନାନ୍ସ ପଢିବେ ଗୋଟେ ରିଭିଜନ ର ସ୍କୋପ କଣ ଇଟ ଇଜ କ୍ଲିୟରଲି ସୁପ୍ରିମ କୋର୍ଟ has stated ଚାରି ପାଞ୍ଚଟା ପ୍ରିନ୍ସିପଲ ଅଛି if the trial court has correctly appreciated the evidence this court cannot take a different view unless it is a sanctuary of errors. The problem case file kale paisa milibani boli equity provision ଅଛି ସେଟା କହିବେ make a serious submission ବୁଝିପାରୁଛନ୍ତି ଆପଣ what you are saying may be otherwise emotionally or କଣ ଆପଣ କହିବେ ଦେଖନ୍ତୁ
Item 5.
entry model
Item 16 ଟା adjourn ହେଇଯାଇଛି
16
ହଁ ଏଥିରେ ଏଣ୍ଟ୍ରି ମଡର ଟା ଆଗରୁ ଥିଲା
ଯୋଉଟା entry model ଥିବ ଆପଣ
ସେ ଖାଲି ଲେଖା ହେଇନଥିବ କାଳେ ଏଣ୍ଟ୍ରି
ନାଇଁ ସେଟା actually ମୁଁ dictate କରିନି ଆଉ ମାନେ what I'm doing that ଯୋଉଟାକ simple adjournment ହଉଛି ତ computer ରେ post କରିଦଉଛି that saves time ସେଟା order କରିବାକୁ ପଡିବ Mr. Sharma order number ଜାଣିଛନ୍ତି date ଜାଣିଛନ୍ତି
ଏଣ୍ଟ୍ରି ମଡର
I'll see that. When the matter is called, I'll see. Right. Okay? I don't know. So.
तेईस 11/2016 एंट्री मॉडल
कौन डेट केवे करते थे 16
11/5
23 11 16 क्वेश्चन मिस्टर मिश्रा
Your Lordship, one IA has been filed for insertion of state of Odisha repented through Secretary to Government Home Department, Your Lordship. That IA has been filed IA number 24 of 2026. For opposite party number 1, Your Lordship. So this may kindly be item 5, Your Lordship. Last occasion, it was pointed out that only state of Odisha has been made a party, and this case for seeking transfer the matter from OPID court to special judge CBI Bhubaneswar, Lordship. So I have made CBI as party and opposite party number only state of Odisha, and after that,
सर स्पेशल कोर्ट को कितनी नॉर्मल करके ट्रांसफर हो
Sita, Your Lordship. Sorry, Your Lordship. Page 30, Your Lordship, I kindly see. Page 30.
विजन टाइम कोई भी सर let us
Sir, Sita,
I seek your assistance
yes, Your Lordship.
ते एजुकेट करिवे
Lordship,
प्रोविजन डेटा गोटे माने ओपीआईडी
Yes.
स्पेशल
Your Lordship, Honorable Supreme Court.
स्पेशल कोर्ट इज डिफाइंड
Yes.
एस्टाब्लिशमेंट जोटा अछि स्पेशल
Sita, 2013 Honorable Supreme Court passed a judgment. I have annexed it as Annexure 1. Your Lordship may turn to page 30. Page 30. Citation no এটা citation no এটা তার ফর স্টেট অফ ওড়িশা এথে যোগুডা সব চিট ফন্ড স্কাম রে সব সেতেবেলে হেইতিলা স্পেশাল কোর্ট এস্টাবলিশ ହେଲା যেতে গুডা স্টেট অন্ডর রে থিলা পুলিশ অন্ডর রে সব জায়গা সিবিআই কু গলা সেথে দুইটা কেস থিলা আদর্শ গ্রুপ এগেইনস্ট রে গোটে কেস চালি গলা গোটে রহি গলা এটা ওপিআইডি কোর্ট এস্টাবলিশ ହେଲା ପରେ এଠି রহিছে
ଆପଣ କହୁଛନ୍ତି
ଆଜ୍ଞା
ଗୋଟେ ଲାଇନ କହିବେ
ଆଜ୍ଞା
as per supreme court direction କେତେ ସମୟ ଲାଗିଲା ଆପଣ ସେଟା ମତେ କହିବା
ଲର୍ଡସ୍
ଆପଣ ଯୋଉ ହଠାତ୍ कोर्ट फ्रॉम ओपीआईडी टू स्पेशल
मोर दैट्स माय प्रेयर
अरे प्रेयर कोर्ट से तो सुप्रीम कोर्ट कहले प्रेयर
copy of the TRP served on you.
अच्छा कॉपी नहीं
No copy. Also, I
ଆଜିକାଲି କପି ଦିଆଉନି ବୋଲି ସେ ଦେଇଦେବି ମୁଁ ଗୋଟେ କପି
he submitted had Mr.
yes yes
I think ଆପଣଙ୍କର after you produce the High Court ର କଣ rule ଅଛି
ସେଥିରେ କଣ yes
sentence ଟା complete କରିବାକୁ allow କରନ୍ତୁ
your lords
this order is passed by Supreme Court it is binding on all courts
yes
then if you produce it before the OPID court it will automatically go
Annexure 7 your lordship I filed petition before OPID court also request letter to CBI के किसी करो CBI नेबे पर ट्रांसफर करके एथरे सुप्रीम कोर्ट
स्टेशन को पड़े
your lordship
we are concerned with the trial
OPID court रे फाइल करते আছে annex
signature दिया हो इंडियन का दिया हो स्टेट ऑफ ओडिशा सेटा अलग
your lordship annexure
चाहे नहीं क्यों
lordship annexure 5
where your contention that Supreme Court order
आज्ञा
as simple as that
your lordship annexure 5 page 50 I have filed petition
ठीक है जी instruction देबे I think that is not no I think once Supreme Court directs means it has to go
your lordship
so what is there to be adjudicated by this court I don't understand also
lordship when I filed petition before OPID court said that I have no power to transfer the case from
definitely
so then I got
how OPID court will transfer doesn't have power
power nice
but
better you approach CBI
Supreme Court order CBI
Somebody letter then.
CBI letter
Say-
Supreme Court order operative portion को भी-
Operative portion page 30 your lordship. Page 30 annex 1.
अरे page का paragraph कहेंगे।
Page
Operative portion
state of Odisha, all cases registered, page 30 annex 1 your lordship.
हाँ fine को paragraph
Paragraph B for state of fourth paragraph. Fourth paragraph your lordship. B like state of Odisha. All cases
Which is Maman.
annex 1.
Then city अच्छी आपको यही सर आपको अने सर वन क्लिक करो तो पेज 30 34B
पजा तो last one page 30.
नहीं स्टेट है बुक मार्क टच करो
30 state of Odisha. All cases registered against 44 companies mentioned in our order dated 26th March 2014, passed in WP writ petition civil number so and so. The CBI is also permitted to conduct further investigation into all such cases in which charge sheet have already been filed. And 35 page, then 35 page 35.
Page 35.
Page 35 रे से FIR कले दीटा केस थिला पेंडिंग थिला सेतबळे गोटे जाजपुर रे
ट्रांसफर केला बेले कोड कोचनी कोड
एटा ई सब जगह पर सब जगह केस ट्रांसफर आसिला पेज 35 योर लॉर्डशिप में काइंडली सी
आपण कोचन जे 34B जदी हला परे
सब केस उडा चली गला या अगेंस्ट दुईटा केस थिला दुईटा केस
ट्रायल कोर्ट कोचन जे सीबीआई को मूव
सीबीआई को मूव करिया अपना से कहले सीबीआई को देलु से किछि करना नॉट फाइंडिंग अल्टरनेटिव फाइल दिस ट्रांसफर पिटिशन फॉर ट्रांसफरिंग ऑफ द केस फ्रॉम ओपीआईडी कोर्ट टू सीबीआई सेठी ट्रायल चालू छी ना ओपीआईडी कोर्ट रे जुरिस्डिक्शन नाही as per the order of the honorable again
36
page 36
अरे पारा 36 कौन खाली पेज चले चलिए
transfer of investigation
36.
again transfer of investigation to the Central Bureau of Investigation CBI in terms of the order shall not however affect to the proceeding pending before the commissions of inquiry see olga katha जो
कोणो तो आगे होगा तो
again commission of inquiry established by the state government or stall any action that is legally permissible for recovery of the amount for payment to the depositors.
এটা ওপিআইডি
এটা OPID
কোন সুপ্রিম কোর্ট ডাইরেকশন এর আই পিরিয়ড সুপ্রিম কোর্ট has said on the contrary legally permissible for recovery of the amount for payment of the depositors because OPID is only for recovery.
OPID রে দুইটা কেস
আপনাদের ক্রিমিনাল পার্টটা ইয়ে হবে
সেটা ক্রিমিনালটা সেটি চলছে সেটা
not petitioner for merit
and this particular
you এটা 36 রে যদি আপন ভেরিয়েশন চাହୁଛନ୍ତି হাই কোর্ট cannot vary
and the particular petitioner who is the accused person he, by confessing guilty already he has been sentenced
যদি সে কনভিকশন হেলে ন হেলে আর রিকভারি আর ডিফারেন্ট থিংস
OPID
সে যদি সে if they have he has আপন OPID র প্রসিডিংটা দেখেন
OPID proceeding annexure summon sorry page 49 your lordship
order पे
order nahi page 49 order kichhi hai I just filed vakalatnama and filed a petition to transfer the case and annexed the summon your lordship page 50 page 50 I filed a petition before OPID court
सुप्रीम कोर्ट मना करे लाइब्रेरी
OPID सेतरा आक्ट हे नथिला आसी नथिला OPID act तापरे आसी establish हला
so my understanding is correct OPID is not a prosecution
OPID कोटा अछि ठीक
अरे जोटी थाओ एपटी रहले कोन सुविधा होची
OPID से
तो that doesn't mean बाम पटे चले एटा prosecution नहीं जो डान पटे theory prosecution तले काय कि आपण
OPID
क्रिमिनल केस थला यदि पेंडिंग थिबो से सेटिंग थिबो
से क्रिमिनल केस टा OPID को चली आसिला गोटे केस चली गला CBI की गोटे केस रहला OPID को सेटा that was the duty of the CBI authority to transfer all the cases to one court as per
36 is very clear ऐड करो ओडिया सेंटेंस रा ऐड करो तुम इंग्लिश पढ़ो
needless to say that the state police agencies currently investigating the cases shall provide the fullest cooperation to the CBI, including assistance in term of the men and materials to enable the letter to conduct the complete the investigation expeditiously. So, Your Lordship, there are 2 cases were pending.
Then can you read further?
For page para 38. It make it clear. Lordship,
37 AD.
37, para 37 I have 37 already I have read. Transfer of investigation to the Central Bureau of Investigation CBI. That is, the Enforcement Directorate shall in meantime expedite the investigation initiated by into the scam of the institute appropriate proceeding based on the same in accordance with law. That is, my lord, for
Obviously, so said the OPID is not kind of it's not a prosecutor. That is my. You have to accept it.
OPID Act
OPID
was
Act is not for.
enacted, and thereafter OPID court was established,
Correct, sir.
and one case was transferred, another.
जोटा CBI है वो crime branch investigate करते हैं, but IPC offense.
See the IPC offense, it is OPID रे भी IPC offense selves. Same section, right?
And Supreme Court is very clear on this.
OPID after establishment of there are your lordship,
ଯଦି ପଢିବେନି sentence ଟା ଓଡ଼ିଆରେ କହିବେ କି ଲାଭ ନାହିଁ.
your lordship, there are 2
The
cases.
state government or stall any action that is legally permissible for recovery of the amount for payment to the depositors. So that action is initiated under OPID. The learned counsel for the petitioner was heard at length. The learned additional standing counsel submits that he may be provided with extra copy of the petition always and the annexes. The learned counsel for the petitioner shall provide an extra copy within 2 working days. Within 2 working days. The prayer made in the petition is reproduced here. The learned counsel for the petitioner relies on the judgment of the Hon'Ble Supreme Court. Page 14 देखिए. Subrat Chattoraz versus Union of India. Colon date 2014 into bracket close into bracket 2014 bracket close 8 SCC 768. Okay, 2014 into bracket and 8 SCC 795. Check it. Then column 2014 INSC 390. Stuff. The copy of the judgment of the Hon'Ble Supreme Court into bracket Monopatra P has been annexed to the writ application. The learned counsel for the petitioner refers to paragraph 35, paragraph 34B and 35, which are reproduced here. SCC to देखिए लिखी रहता हूँ. 34 in the circumstances to the CBI. Tinta dot capital state of Odisha. All cases registered up to already been filed. Stop. Double book. The counsel for the petitioner as well as the learned state counsel are apprised of paragraph 36 of the judgment of the Hon'Ble Supreme Court. In fact, Monopatra print. Which is reproduced here in 36. in view of the direction of the Honorable Supreme Court, that the order shall not, however, affect the proceedings or stall any action that is legally permissible for recovery of the amount of payment to the depositors. Then tinted out. Quotation close. In view of the learned counsel shall apprise this court whether the pending OPID cases which are meant for recovery of can be transferred to be taken up by the special judge CBI. Special court, na kon kurchan?
Initially, that case was pending before the SDGM Jajpur. There are two cases.
You are losing track. ଯେତେବେଳେ SDGM ଯାଜପୁରରେ ଥିଲା ସେତେବେଳେ OPID OPID Act is a special court, special statute. OPID ରେ ହେଲା ପରେ ଆଉ SDGM
Your Lordship,
OPID court.
two cases were pending against Adarsh Group.
Two ho ki 20 ho.
44 companies Supreme Court.
Case ପଡିଲା ବୋଲି. ବହୁତ case CBI ପଡିଲା ବେଳେ କଣ Supreme Court
ସେତେବେଳକୁ ଦୁଇଟା against two cases were.
I hope you understand or
Your Lordship,
Your
Lordship, in the year 2013,
you have para 36 OPID case transfer over and you have no answer.
that was
record hela the
one.
To address the issue. If the Supreme Court direction transfer ହେଇଛି ତାହେଲେ OPID case that you have to say.
Yes, sir.
ଆପଣଙ୍କର confusion ରେ କିଏ transfer କରିଦେଲା, but Supreme Court says that it shall not. Supreme Court has also very clearly said ଯଦି OPID case transfer ହେଇକି ସେଠି ବି trial ହଉଥିବ ସେଟା ମୁଁ କହିପାରିବିନି, but that you have to tell that as per Supreme Court direction.
One case has been done. Yes, Your Lordship. One case was transferred.
ସେଟା ଆପଣ ବାରବାର କହୁଛନ୍ତି ଯାଜପୁରରେ ଥିଲା SDGM ଙ୍କ ପାଖରେ କଟକ ଆସିଲା ଦିଟା କେସ୍ ଥିଲା ଗୋଟେ କେସ୍ ପଳେଇଲା CBI ଗୋଟେ କେସ୍ ଅଛି. How this will help you? I don't understand. You can get a clarification from Supreme Court, that's a different thing or whatever.
Your Lordship, as per the order of the Supreme, at that time, 44 listed companies.
PID କଥା ପଢିଛି ଆପଣ ସେତେବେଳକୁ 44 cases
44 companies at the 2013.
Repeating one the facts it doesn't improve.
Even
if you are thinking
Your
that
Lordship, I will take instruction. Lordship, I will take.
definitely whatever
I will take instruction. I will take instruction.
so repeating the facts.
No, Lordship, I will take instruction.
answer दो ही ना ଆପଣଙ୍କୁ 36 ପଢିବା ପାଇଁ କେତେ ସମୟ ଲାଗିଲା ଆପଣ ପଢିଲେନି para 36. Yes, next. Keep as matters have been listed for pressure the convention. 11
Seven.
Yes, 7 minutes. This petition is filed under section 24 of.
You have power here.
Yeah, well, I have already filed Bakalatnama and yesterday.
So Konda is no more appearing.
No, ma'am. Its name may be deleted, but it has been transferred.
Okay, people.
Yesterday, I have got the receipt, ma'am.
So let it come on record. Miss Das. Purana naam ki?
Mrs. Sarda Das. It is there in the pause list, ma'am.
Petitioner लिखी हुई है. तो Sarada Das तो आश्चित है.
Yes, ma'am.
अच्छा अच्छा. Miss Sarada Das for the petitioner. Which is party plan. Submitted by the Honorable Counsel for the petitioner that she has filed Gokulatama will be executed by the petitioner as she has obtained change. After obtaining consent, he has obtained change with consent, not obtaining, with consent from the Honorable Counsel who was appearing earlier. So Gokulatama is stated to have been filed
On 6th of this month, ma'am.
on 6/4/2026. The Okalatnama shall be recorded. ଆପଣଙ୍କର ବିନା ଓକାଲତନାମାରେ କେମିତି ନାଁ ଆସୁଛି?
ବକାଲତନାମା ଫାଇଲ କରିଛି ସକାଳେ।
ରେକର୍ଡ ଆସିଲି ଦେଖେଇବ। The Okalatnama shall be tagged to record. If asking matter shall be listed for fresh admission.
No, my lord, I kept it for tomorrow because the date is posted for tomorrow. That's why I mentioned the matter yesterday, because lordship, the petitioner will be highly prejudicial.
That repairing file can be put for. You must understand the mechanism. जो कोर्ट मैटर टा कोर्ट रे होची सेटा 10 थे टेक्स टीचर्स संध्या 8 9 रे कर वन सेक्शन बंद हुए 5 जे वेट फॉर अस छोटा प्रिपरेशन छोटा मैक्सिमम होई करी so they have a 10 to 5 9 to 5 job but see then they wait.
Is it possible to take day after tomorrow?
Yeah, so tomorrow find the very soon. Day after tomorrow. At least the file can unless the physical file goes, they cannot attach the Okalatnama.
Then you will also make keep it on Friday, it will be.
Day after tomorrow,
Okay.
the matters are listed for fresh admission.
8, 9th of. At start, 9th.
Sorry. Very much. Now, Chari put in service. Name of Mr. Upon writing of the Okalatnama, name of Mrs. Das and Associates, Mrs. Das, Knowledge Counsel and Knowledge Associates have been reflected in the cause list as well as the case brief according for commissioner. So, para name of the Knowledge Counsel who are appearing on the shall be deleted. Yes, next.
Item A.
Petitioner none. None appears for the petitioner or the matter is called. Here the matter was had at some day. And then as reflected in order dated 28/3/24. Para to grant further opportunity list in the list for fresh admission in the week of election. 4/5/24.
Item 9.
Item 9. In item number 1 and sub-item number 3, Shams, the petitioner has expired. In the
So the
main,
noting, have you checked the noting?
yes, sir, Lordship.
Steps for the substitution of legal heads of petitioner not yet taken.
We have already filed IA number 6351 and 6353.
Just a second.
It is not
You are for the petitioner. Miss S. Das for the petitioner. WPC 5199 of 2013. We'll go one by one. Order order ko bhule hi mix up hi. Mr. Pradhan Prasanna Behera.
That's 1 to 5 months.
Additional standing counsel for the petition da kode gala.
It's for OP number 1 to 5.
Additional documents would have
हमें 5 point. Civil support.
Yes, it's wrong. भूल लिखा है.
And Mr. Prabhu Prashanna Behra, Additional Standing Counsel for parties 1, 2 to 4. 4.
Mr. Jaipal for OP number 6, my lord.
4 and 5, the 5 civil supply.
5 my lord.
Mr. Samir Mr. Senior Counsel along with
ଜଗଜନ
Mr. JJ. ଆପଣ କଣ ତ ଦେଖା ନଥିଲେ
ଦେହ ଟିକେ ଖରାପ ହେଇଥିଲା ଷ୍ଟ୍ରୋକ୍
ଆରେ ତୁମର
6-7 ମାସ
ଆପଣ କଣ ଦେହର ଯତ୍ନ ନେଉନାହାନ୍ତି?
ବିପି ଔଷଧ ଖାଉଥିଲି କିନ୍ତୁ
come back. Mr. ଆପଣଙ୍କର ନାଁ sir?
Mr. On behalf of Jaipal, your lordship.
अच्छा. Mr. Jadip Pal along with Mr.
Ranjit Mahapatra.
Rajit.
Ranjit.
Mr. Ranjit Mahapatra for OP6. Stop. It is submitted by the learned counsel, Ms. Das, Prafulla Kumar Ratha, Senior Counsel Lecture.
Senior Counsel
The petitioner, so Prafulla Kumar Ratha, Senior Advocate, along with Ms. Shraddha Das for the petitioner. It is submitted by Ms. Das, learned counsel, that though office note indicates that steps for substitution of legal heirs has not been taken, but IA has been filed for substitution.
Yesterday, 6th.
Has been filed on 6/4/2026. Copy of the IA shall be served on all the.
Have already been served.
Copy of the IA has been served on the learned counsel for the appearing parties. Stop. अपने objection कार्ड दबार थिबा दे दियो. The IA shall be considered on the next date. All the other parties shall have the liberty to respond to the IA if so advised. Status quo notice return unserved जोटा दरकार नहीं समझ appear करछंती.
समझते कर सारणी appear.
Petitioner भी unserved ही गला. Petitioner यही तो चल जाती है उससे unserved होती हो. अठारह 4/13. So it is pretty old notice. अपन मतलब appear करछंती अपन.
Actually, it has been heard completely by the previous.
The office note regarding non-service of status quo notice shall be ignored in view of the fact that all the parties are represented before this court. So बहुत लंबा noting लिखा है. तापरे आपण ई जो substitution टा आ गोटे को मैटर कहउछंती.
The third subitem
WPC 12847 of 2013.
Yes, sir.
12847 Mr. Mishra आपण को का पे
मु आज्ञा सेही ऑक्शन परचेजर but I am in WPC now 35582 2020.
12847 रे
अच्छांति मिस्टर
Ranjit is appearing.
हां सेही ऑक्शन परचेजर.
Mr. Behra, you are there. That same appearance, right? 12847, same appearance, same order. Just जो notice regarding status quo notice से जोड़ा से लाइन था तब क्या नहीं. 12847 से noting नहीं. Now WPC 5401.
5401.
Sharma, Senior Counsel.
I am on BC, my lord. I am for the
He's
petitioner.
appearing in the last occasion. Today is not appearing.
Chamber की ना
No, yes.
या कले अपना फास्ट यदि ता मैटर लिखले the matter shall be listed in the এটা কোন অর্ডার না আফটার নোটিস এটা আপনার কমপ্লিট হইছি
এটা
হিয়ারিং ফর অ্যাডমিশন এটা হিয়ারিং হতলা
এটা হিয়ারিং চলতা রিটেন নোটিস ফাইলিং
লিস্টেড ফর অ্যাডমিশন ইন দ্য উইক কমেন্সিং 11/5/2026 WPC 5199 12847
ऑर्डर से डिस्पोज ऑफ जदी एही पर कंसेंट ऑफ द पार्टीज कहि
सर हियरिंग कले प्रॉब्लम कोन होबा कि जो असाइनमेंट जा अछि बहुत गुड़े मैटर आपनकर फ्रेश एडमिशन भी हियरिंग होच
ଆଜ୍ଞା
so
ତାହେଲେ
we
ସେ
cannot cross the list actually ସବୁ matter we have to be I mean
ଟିକେ ସର୍ଟ ଡେଟ୍ ପ୍ରେୟାର କରୁଛୁ ବିଫୋର
shortest
Shortest.
short date ରଖୁନି shortest date
ସର୍ଟେଷ୍ଟ ଟିକେ ଆଜ୍ଞା ଟିକେ
shortest पर 11/5
ଆଉ ତା ପୂର୍ବରୁ
ଆପଣ shortest ଯୋଉ ଅଛି
ଆଜ୍ଞା
going for the shortest date ତା ଆଗରୁ ବି ଅଛି ତା reason ଅଛି
we'll try because ସେ all the
ଆପଣ ଟ୍ରାଏ କଲେ ହବନି ସାର୍ ସେଟା କଣ ହେଇଛି କି 13/4 ରେ 102 ପହଞ୍ଚି ଗଲାଣି
ଓହୋ
20/4 ରେ 97 27/4 ରେ
no as
50
per lordship's convenience
No, no.
ନାଇଁ I will not
no it's not my convenience it is your convenience actually ମୋର ଏଥିରେ convenience କଣ ଅଛି
ଏତେ ଲୋଡ
I'm sitting ନାଇଁ ଲୋଡ କିଛି ନାହିଁ ସାର୍ ଜଣେ ବସିକି ତ କରୁଛି ଆଉ କଣ ସେଟା ability ତ ଅଲଗା କଥା ପ୍ରୋବ୍ଲେମ ହେଲା ଯେ ଲିଷ୍ଟ କରିବାଟା ଯେତେ ଇମ୍ପୋର୍ଟାଣ୍ଟ ନୁହଁ ଟଚ୍ କରିବାଟା ବି ଆହୁରି
ଟଚ୍ କରିବାଟା
ତ ବାକି ଫ୍ରେଶ ଆଡମିସନ ଅର୍ଡର୍ସ ଆଉ ଯୋଉ ମେନସନ ମ୍ୟାଟର ତା ଦେହରେ ଆଡ୍ ହବ ସେ କେତେଟା କୋଶ୍ଚିନ୍ କହିବା କଥା ଯେ ପଚାରୁଥିଲି 102 କାହିଁକି ହେଲା ଗୋଟେ ଦିନ ଆପଣ ଏତେ କାହିଁ ଗୋଟେ ୱିକରେ ଭର୍ତ୍ତି କରିଛନ୍ତି 102 ରେ ଆଉ ବାକି 5 ଦିନରେ ତ ଆପଣ ଆହୁରି 100 ମ୍ୟାଟର ଆଡ୍ କରିବେ ପାଖାପାଖି ରଫ୍ ଏଷ୍ଟିମେଟ 2 ତାରିଖ ଆପଣଙ୍କର ଯୋଉ କୋର୍ଟ ହେଲାନି ସେ ମ୍ୟାଟର ସେ ଆଡ୍ କରିଛନ୍ତି ଯେମିତି କିଛି ହଉଛି ଆଉ
ମୁଁ ପ୍ରେୟାର କରିବି ସବଜେକ୍ଟ ଟୁ ମାଇ ଲର୍ଡସ୍ କନଭେନିୟନ୍ସ କେସଟା କଣ କହୁଛି 2004 ର ସାର୍ଟିଫିକେଟ କେସ୍ and I am the auction purchaser 2012
what you said I remember
ତେଣୁ ଗୋଟେ ଦିଟା ବେଳକୁ ଗୋଟେ ଫିକ୍ସ ହେଲେ କାରଣ ସିନିୟର କାଉନସିଲମାନ ରହୁଛନ୍ତି ସେମାନେ
ଦିଲ୍ଲୀ ଆପଣ ଯୋଉ ପୁରା ଦିଲ୍ଲୀ ପଳାନ୍ତୁ ଆଉଟ ଷ୍ଟେସନ କାଉନସିଲ ହେଇଯିବେ ସେତେବେଳେ 2ଟା ବେଳେ ହେବ
ନାଇଁ ମୁଁ କହିବା କି
ଆପଣ ମିଷ୍ଟର ରଥ ଆଉ
ରଥ ମିଷ୍ଟର ଶର୍ମା
ତିନି ଜଣ ଯାକ ଦିଲ୍ଲୀ ପଳାନ୍ତୁ
ସାର୍ ତେଣୁ ଆମର
ଆପଣଙ୍କ ଯିବାର କିଛି ଅସୁବିଧା ନାହିଁ
ନା ଆଜ୍ଞା ମୁଁ
ଯାଉଛନ୍ତି ଇନ ପର୍ସନ ଯେମିତି ଆଜି ଗୋଟେ 2ଟା ବେଳେ ଅଛି ସେ ଇନ ପର୍ସନ ସେଟା ବେଞ୍ଚ ୱାଜ ନଟ୍ ଆଭେଲେବଲ ବଟ୍ ସେଟା ସେମିତି ହେଲେ ହବ
ମୁଁ ପ୍ରେୟାର କରୁଛି କଣ ଅନେବଲ କୋର୍ଟ ପାଖରେ ଯେହେତୁ
ଆପଣ ନହେଲେ ତାଙ୍କ ସାଙ୍ଗରେ କଣ କରିକି ତାଙ୍କ ପାଇଁ ନିଜେ ପିଟିସନର ହେଇଯାଆନ୍ତୁ ଇନ ପର୍ସନ ହେଇଯିବେ so there are two ways only ସବୁ କାରେ ସେମିତି କରିବାଟା ହବନି ମିଷ୍ଟର ମିଶ୍ରଙ୍କ ମ୍ୟାଟର ଖାଲି 2ଟା ବେଳେ ନିଆହବ ଅନ୍ୟ ମ୍ୟାଟର ତା ଦେହରେ ଅଛି କେମିତି ହବ so now 5401 of 2013 inform Mr. Sharma the associate Mr. Vigyan Sharma along with so and so for the petitioner state by Mr. Prabhu Prasanna Bera 5401 yes sir Pradeep Kumar Mahanti ko pai ki apna per kuch Mr. Samir Mishra senior counsel along with Mr. J Pradhan for 4 তারপরে 5 Mr. Jadipal with Mr.
R
Mahapash Ranjit Mahapash the matter is listed with the connected WPC 5199 of 2013 stop shall be listed along with the said matter on in the week commencing 11/5 2026 ଆଉ ଗୋଟେ ରହିଲା 35582
ସେଥିରେ ମୁଁ ଅଛି ଅକ୍ସନ ପର୍ଚେଜର ଏଗେନ୍ଷ୍ଟ ଦି ଷ୍ଟେଟ
35582 of 2020 Mr. Lalitendu Mishra for the petitioner
auction purchaser
the learned counsel for the petitioner appearance of justice Mr. Prabhu Prasanna Behra additional standing counsel for the opposite parties 1 2
3 4 and 5
yes ଆପଣଙ୍କର 6 ଅଛନ୍ତି ତା ଦେହରେ
6 ଆସିଲେ ପହଞ୍ଚିଲେ
ଆପଣ ଆଙ୍କୁ ଆଡ୍ କରିନାହାନ୍ତି
ନାଇଁ ମୋର ଅଛି ଯେହେତୁ ଅକ୍ସନ କଲେ ୱିଦାଉଟ୍
the learned counsel for the petitioner expresses concern that he is the auction purchaser and he's not getting the benefit of the purchase
by not
due
getting
to
the road
pendency of the
yes
connected writ applications
grateful
the matter shall be listed along with the connected applications on in the week commencing 11/5 yes
obliged
In the first item, there is an interim order.
first item जोड़ा अछि interim order एक date कोई परिवे
Interim order and
interim order shall continue till the next date of hearing 5199
From 11
ତିନିଟା ସେ ଗୋଟେ ତାଙ୍କର ମଦର ଇନ୍ ଲ ଚାଲିଗଲେ।
କେବେ ଆସିନାହାନ୍ତି ଆଜି ଆଡଜର୍ନ କରିଦେଇ ପଳେଇଛନ୍ତି।
କହୁଛନ୍ତି ଯେ ମଦର ଇନ୍ ଲ ଫାର୍ଷ୍ଟ ଟାଇମ୍ ପାଇଁ ଚାଲି ଯାଇଛନ୍ତି ତ କହିଲେ। ସେଇଟା ସେ ଯୋଉ ଆସିନାହାନ୍ତି ଆପଣଙ୍କ ଆବସେନ୍ସରେ ମୁଁ ପୁରାଟା ଲେଖିଛି ଯେ କୋଉ ଦିନ କଣ କଣ ଆଡଜର୍ନମେଣ୍ଟ ହେଇଥିଲା। Item 10, Mr. Again? One second. Item 10 ଟା କଲ୍ କରିଦିଅନ୍ତୁ। ସେ କହିଲେ ଯେ ଆପଣଙ୍କୁ ଇନଫର୍ମ କରିବେ ବୋଲି କରିନାହାନ୍ତି ଆଉ କହିଥିଲେ। Because this is happening, because you are expecting the matter to reach in order. So, ନାଁଟା actually କହିପାରିବେ? ଆଶୁତୋଷ ଦେବତା on behalf of J.M. Patnaik. ଅର୍ଡରଟା କିଏ ନେଇଥିଲେ? ଅମିତକୁ ନେଇଥିଲେ। ଆଡ ହବ ଏଠି ଖାଲି ଲେଖିଲେ। ମିଷ୍ଟର ସୁଧାଂଶୁ ଶେଖର ପ୍ରତାପ
ଇଣ୍ଟରନାଲ
ମିଷ୍ଟର 10 ରେ ମିଷ୍ଟର ବେହେରା ମିଷ୍ଟର ଲେଙ୍କା ଷ୍ଟେଟ 10 ଷ୍ଟେଟ ପାର୍ଟି ଅଛନ୍ତି। ମିଷ୍ଟର ପ୍ରଭୁ ପ୍ରସନ୍ନ ବେହେରା ଆଡିଶନାଲ ଷ୍ଟାଣ୍ଡିଂ କାଉନସିଲ ଫର ଦ ନମ୍ବର 1 and 2 ମ୍ୟାନେଜିଂ କମିଟି ସବୁ ଆପଣ ଗଭର୍ଣ୍ଣିଂ ବଡି ରଘୁନାଥ
ସେ କେହି
ଆପଣ କାହା ପାଇଁ
ଇଣ୍ଟରନାଲ
ଓପି ନମ୍ବର 3, 4 and 5 ନନ୍ ତାକୁ ଯଦି ଇନଫର୍ମ କରିଥିବେ ମୁଁ କହିପାରିବିନି ବ୍ଲାଙ୍କ ଛାଡ଼ି ଦିଅନ୍ତୁ ନନ୍ ଆପେନ୍ସ ଲେଖିବେ। ମିଷ୍ଟର ଏସ୍ ପ୍ରତାପ ଫର ଦ ଇଣ୍ଟରଭିନର ତାପରେ ସେ ଅର୍ଡରଟା ଯୋଉଟା ଅଛି ଲେଖିବେ। ଏବେ ଡେଟ୍ କରିଛନ୍ତି 4/5। ନେକ୍ସଟ କଲ୍ କରନ୍ତୁ
11
ଲେଖନ୍ତୁ ମିଷ୍ଟର ଦେବବ୍ରତ ରଥ ଫର ଦ ପିଟିସନର। Anyone for the opposite party? Opposite party blank. Okay, but non कर दो। Appearance मध्ये वनिता दीप ଅଛନ୍ତି ତ ପ୍ରଣୟ ମହାନ୍ତି। Opposite party non। लिखिए ऑर्डर डेट 24/3/2024 रे para 1, 2, 3 para by order dated 24/3/2024 college was directed para 4 टा quote कर देते तापर next para 5 the efforts of the registry to intimate the learned counsel for the petitioner the efforts of the registry to contact with the learner has yielded results. The learned counsel for the petitioner files memo of date, which states thus. Secretary SIC lectures. The memo is taken on record, scanned copy be updated. The petition stands disposed of. In view of the report received from the JMFC dash English 1 into bracket cognizance taking of the bracket closed comma Puri dated 9/3/2026 received in the registry. Copy of the letter code. In view of the copy of the letter. That the matter is pending before the said Lord JMFC. Into bracket cock taking, cognizance taking, dash English 1, bracket close, comma Puri. And it has been sent for mediation. In the mediation for nation 2.0 drive. And report from the DLSA is awaited. It is a rule, the letter dated copy of the letter indicates that. About correct also correction. Copy of this order shall be forwarded to the learned so and so as well as the DLSA Puri to be tagged to the records of the case. 1 CC 155/2019. Yes. Yep. The petition is disposed of. All the entry models passed earlier stand vacated. Yes, next.
Item 12.
None appears for the petitioner when the matter is called. Stop. The petitioner is also absent on repeated call. Stop. The matter was presented before this court on 16.09.2022. For removal of defects, it was listed before the deputy registrar, not a deputy registrar, if you bracket judicial, then comma logima. And 3 weeks time was 3 weeks time was granted. Weeks is for extra. On 17/3/2026, the matter was listed before this bench, and 2 weeks time time was granted for removal of defects as prayed for. Stop. Till date, the defects are spotted by SR. Dated 20/10/2022 have not been removed. Stop. The matter shall be listed or listed in the week commencing. The picture. Indicating that it shall be listed for orders. Matter shall be listed for orders in the week commencing. Indicating that matter shall be disposed of. Copy of this order along with the next date of listing shall be intimated to the counsel for the petitioner. What would a date कर दे तो better हो? 25 तारीख को 29 को 29/4/2024. Yes, next.
30.
Neighbors. No instruction mail.
Srikanta Mahunta.
Mail.
Of the petitioner.
No instruction mail.
What the memo ଦେଇଛନ୍ତି ଗୋଟେ କାଗଜ ଦିଅନ୍ତୁ.
No.
The matter was presented before this court on 21/10/2022. It was listed before the 21/10/2022. Stop. Stamp reporting was done on 29/10/22. As the defects pointed were not removed, the matter was listed before the Lord Deputy Registrar Judicial on 21/11/2025, when 3 weeks time was granted for removal of defects. On 10/3/2026, the matter was listed before this court. Further time was granted for removal of defects. So it was also directed to intimate the learned counsel for the petitioner. So today, when the matter is taken up, memo of date is signed by the learned counsel for the petitioner, which states thus. Stop. Accordingly, the petition is disposed of. Copy of this order shall be forwarded to the Learned Judge Family Court Bhadrak, will be kept in the records of CR.P. number 165 of 2018. Disposed of by judgment dated 7/9/2022. Yes, next.
What the
Subhasis Mahapatra for the petition. You are Mr. Mahapatra.
Yes, sir.
Subhasis Mahapatra for the petitioner, Mr. Mahesh Das, Mr. Raut. So BB Raut for the opposite party. Affidavit not filed, sort of thing.
Yes, sir. The petitioner, present petitioner often try to pay the amount. Opposite party refused to receive the same. Say, coach, I am court
Court pay scene.
Yes, exactly.
Counsel
Yes.
is approaching. Give me take some money.
The some money.
Take away out of court.
Under the table, no over the table.
No, outside the court fee.
Decree a court debe. A decree is it. Upon receipt debe, jaha paibe paisa.
Se mana kar.
Under the table किसी करी भी होगा.
I said as demand draft before the court.
Yeah, upon जोउतरे नेबे convenient like IMPS, UPI. There are so many methods now because even the ATM counters are being closed. So
we have also asked for the account number.
केबे आपण कथावार्ता है कि जा करचुन करन.
18 रे अछि जेदा कहउछन कोर्ट रे नेबे मु 18 तारिख कोर्ट रिपोर्ट करिबे.
DD रे देबे.
दे दियो देखो डिटेल्स दियो.
ठीक अछि.
ଆପଣଙ୍କର DD ଅପେକ୍ଷା instant method is easier କାହିଁକି?
Exactly.
DD has to be credited again. You have to present it before your bank. If it is a I mean inter-district or clearing नथिबो ताले आगोटे जाके clearing ପାଇଁ ଯିବ. All those things are there.
My concern is my lord, there is the order, the filing date is written in the order sheet 7/8/2023. The 18th of April, I filed a modification of order because of family court. So that I refuse to accept.
It ଆପଣଙ୍କର wrong legal advice. When there is a direction by the court, or even you can receive any amount that is without prejudice. ବୁଝିପାରୁଛନ୍ତି? Referring to the order dated 16/3/2026, it is submitted by the learned counsel for the petitioner. The petitioner shall deposit. ଆପଣ କେତେ ଟଙ୍କା installment 1,50,000 to କେତେ ଦଉଛୁ?
As per my information, 1 lakh. ଲକ୍ଷ ଟଙ୍କା ଦବ ବୋଲି ସେ କଟଲା.
The petitioner will be depositing rupees 1 lakh in form of DD. DD oblique UPI oblique IMPS.
I am supplying a bank account.
At oblique RTGS, NEFT. Which shall be received by the learned counsel for the not learned counsel, which shall be received by the opposite party without prejudice to her rights and content in the present case. So, the matter shall be listed for orders in the week commencing 27/4/2026. And still, if they want to resume the matrimony, you advise accordingly. Make that effort. I don't know. No, I'm just telling you because this is only regarding maintenance.
My lord, it is.
She might be thinking that she wants to resume the matrimony, so she is not receiving the money. in that context, that came to my mind. So I'm sharing my thoughts. Yes, next.
Okay. 15. May I please, Your Lordship?
Yes.
In the present writ petition law, the petitioner, who is the opposite, who is the respondent wife in the court below, assailing the order dated 16/1/2026. The fact remains, my lord. The petitioner here is the respondent wife in the court below, and the opposite party is the husband in the court below. The opposite party referred application under section 13(1)(a) of the Hindu Marriage Act for divorce, seeking divorce, decree of divorce. In that petition, the respondent wife in the court below filed his respective written statements.
Here.
In the written statement, my lord, the opposite party, the petitioner here, categorically ascertained that in para 16B, 16C, 16D, 16E, 16F, categorically alleged the opposite party husband has adulterous attitude to his sister-in-law. That is the categorically alleged in the written statement. To substantiate the facts, the respondent wife in the court below filed an application under order rule 110(2) for implement of the necessary parties for proper adjudication of the dispute.
Who filed the 13(1)?
13(1) husband, my lord. Husband is the husband.
Under which provision of CPC the defendant can require party to be added in the petition?
That is, my lord.
Because you can summon a witness.
Yes.
Whatever I have understood, I have read, so under there has to be a specific provision.
Yes.
So because this cannot be, I mean, it is very well defined statute. CPC is very well defined. I mean, it touches every aspect. So there has to be a provision where a party has to be implemented by the, because if you are adducing your evidence by producing a witness, upon a cross, you will examine in chief and the other side will have the opportunity to cross-examine. That may be the value, the issue may be framed according to the issue. If you are raising a particular point, 16 ABC as you have placed now.
Yes, yes.
So regarding that, if you want to adduce any evidence, that's fine.
Yes.
But you say that in his petition, you want to add a party, how can it be?
No, my lord, what happened, my lord? Suppose what?
No, which provision? Let us
No,
start
that is
with the basic law.
10(2), my lord. Order 1, rule 10(2). May I be permitted?
Rule 10(2).
Order 1, rule 10(2). Normally speaks.
Take a roll. Boyta by upon conduction. You are just leaving me behind. ठीक है, order 1, rule 1 टा पढ़ंतु. बही अछि ना देबी?
No, boy.
दियो CPC टा पढ़ा. Miss Copy, you are having copy? Order 1 टा देखो. Order 1, rule 1. Yes, sir. Don't apply your speed on the book. तो अब किसी लाभ नहीं चला.
Order 1, rule 1, lord.
Again.
Who may
Order
be
1 is parties to suit.
Yes, yes.
Who may be joined as plaintiffs.
All persons may be joined in one suit as plaintiff where any right or relief in respect to
right to relief
or assisting out of the same
arising out of
arising out of the same act or transactions, series of acts or transactions is alleged to exist in such person, whether jointly, severally, or in alternative, and if such person brought separate suit, any common question of law, fact, or arises. who may be joined as a plaintiff.
So this would come into play in case of a non-joinder of necessary parties. Now kindly look at who may be joined as defendants. It is the 1977 amendment, Order 1, Rule 3.
Rule 3. All persons may be joined in the one suit as defendant where any right to relief in respect of or arising out of the same act or transactions or series of act or transactions is alleged to exist against such persons, whether jointly, severally, or in alternative. If separate suit were brought against such persons, any common question of law or fact would arise.
So now look at the prayer in the suit. Anyway, 13(1)(a), so it is a prayer for the grant of decree of divorce.
Yes.
So definitely opposite party cannot be no one other than husband.
No.
Suppose you are in your written statement in section 9 or section 13 you have alleged adulterous conduct on part of the husband.
Section 13.
13.
Yes.
So that is your defense. So you cannot then now you are relying on order 1.
Order 1, Rule 10(2). My lord, in normal circumstances, the plaintiff petitioner is the dominant litis of means master of the suit can add or delete any parties. But Order 1, Rule 10(2) is the exception. But this general rule is subject to the provision of Under 1, Rule 10(2) of the code. The court may at any stage of proceeding. The court.
Upon 10 सबबळे heading टा पढिबे. Suit in name of wrong plaintiff. Then court may strike out or add parties. So 10(2) is a exception to 1(3) according to you.
10(3), my lord.
10(2) is a exception to 10(3). Oh, sorry, 1(3). Case law.
Case law is similar. Yeah, the Supreme Court in reportable.
Then straight away, Supreme Court straight away come to the point.
Yes, my lord. My lord,
Order 10(3), 10(2) is a exception to Order 1, Rule 3. Because 3 clearly bars, because you must understand the purpose of this Order 1, Rule 3. That if you go add 10 parties, the court has to decide whether those parties are necessary parties.
Yes.
So that is the thing. If you are seeking divorce against your husband,
filing divorce against wife.
Because and the other problem, who has raised the plea? As I was asking you, that is relevant. You have raised the plea of adultery as a defense because he says that you have deserted. Most likely, desertion is the plea.
Cruelty, my lord.
Cruelty.
Cruelty, you are alleging.
Yes.
Cruelty alleged by the husband.
Yes.
Correct.
Yes.
So cruelty on. So now, suppose you want to prove this adultery, adulterous conduct on part of the husband. What is the purpose of your impleading the party in his suit?
And that is the suspicious attitude where, despite of repeated request, my lord, the
Supreme Court decision rely करछंती.
The wife is wishes to reside with the husband, with his husband, but the husband deserted.
अरे आपणकर written statement रे आपण कहउछंती ना आपण हेडा आपण अलेज करछंती. शुणंतु आपण 13 फाइल कले, wife फाइल कले. शुणंतु kindly listen so that what I am saying you can understand. Husband फाइल कले 13, wife सित्र 18 statement फाइल कले. In the plaint filed by the 13th, seeking divorce from wife, the husband alleges cruelty, desertion also. You have a defense. So that for that you cannot require the court to add party as a defendant.
So how could I defend? My issues are my issues.
Evidence debe.
Yes, Miller, what I am submitting. My statement.
First of all, you have to read Order 1, Rule 3.
Rule 10 to
High Court cannot, much less Supreme Court. Order 1, Rule 3 cannot be overridden by any court.
Yes. Order 1, Rule 10 to
पढ़िले उतरे आपण को पार्ट आपण सपोर्ट साहाय्य करछि.
May permit with due permission. The court 2 Miller. Order 1, Rule 10. The court may at any stage of the proceeding. any stage of proceeding law, either upon or without the applications of either party, either upon application of the parties or without suo motu, and on such terms as may appear to the court to be just, order that the name of any party improperly joined, whether the plaintiff or defendant, be struck out, and that the name of any person who ought to have been joined,
ଆପଣ ଶୁଣନ୍ତୁ ଆପଣ ଫାଷ୍ଟ ପାର୍ଟଟା ମିଶାନ୍ତୁନି so that you will be both
ought to have been joined,
ଆପଣ ଏଇଠି ଖାଲି ପଢନ୍ତୁ
yes,
and that the name of any person
yes,
ସେଇଠି ପଢନ୍ତୁ
and that the name of any person who ought to have been joined, whether as a plaintiff or defendant will,
can you read further,
or whose presence before the court may be necessary in order to enable the court effectually and completely to adjudicate upon and settle all questions involved in the suit, be added. That means
ଆପଣ 13(1) ରେ what is your stand? You want a divorce or you do not want divorce?
13(1) filed by husband seeking divorce.
What is your stand?
My stand
You are resisting that 13(1) or you are accepting that 13(1)?
No, we are not accepting because the opposite party wife is started because till date, my lord, the husband filed divorce case. The wife only filed a maintenance case. Till date, my lord,
The problem is that
the wife never misutilized the law.
Now, if I record these statements, how it will be incongruous? In a 13(1) application, you want addition of party, so not permissible.
That even
You want addition of a defendant. Correct. So kindly read again 10 suit in the name of wrong plaintiff, then 10(2).
10(2).
Whether the plaintiff may be struck out and the name of any person who ought to have been joined, whether as plaintiff or defendant.
Yes. Plaintiff or defendant.
So you want addition of defendant?
Defendant.
Plaintiff. So now for what? Because you are defendant yourself.
No. I am because the husband has suspicious attitudes. He never added any persons against whom the evidence will be
suspicious attitude regarding wife, or wife is suspecting her husband of
wife is suspecting the husband
adulterous conduct,
because
so that is your defense. How the court will direct husband to add the alleged adulterer as a party?
Because always
Hindu Marriage Act ଅଛି?
What happened? The husband never implemented the rule.
Husband and wife, they cannot make up their mind.
Rule 5 of the Odisha High Court Marriage and Divorce Rule said any person stated adulterous.
That is against your contention. ଆପଣ ନିଜେ against କାଇଁ argue କରୁଛନ୍ତି?
Adulterous.
ଶୁଣନ୍ତୁ ଆପଣଙ୍କର written statement ଆପଣ ଫାଇଲ କରିବେ ନା ଆପଣଙ୍କର relief claim କରୁଛନ୍ତି?
My written statement ରେ
ଆପଣ answer ଦଉନାହାନ୍ତି ଯେ when I am asking you 13(1) ରେ what is your stand? You are supporting the prayer for divorce or you are opposing the prayer for divorce?
I am opposing for the
opposing prayer for divorce.
Wants to reject.
Because suppose there is a there you take that plea by impleading, even assuming, because that is not, that is none of business of this court. Since it is a matrimonial matter, I am just asking you this question, that whether actually the wife is thinking in the right perspective.
Wife is thinking to reject with her husband, but husband deserted without a lawful cause, and due to that suspicious attitude, even
ସେଇଟା ଆପଣଙ୍କର defense.
Even if Lord at this stage, Lord,
you must understand the law has developed allegations of infidelity itself is a cruelty. ଆପଣଙ୍କର କିଏ ଏଟା advice କରୁଛି ମୁଁ ଜାଣିନି, ଆପଣ ନିଜେ evidence court କୁ ଦଉଛନ୍ତି by filing an application to implead the adulterer that you are mentally, because the reason asking you that what is the ground. If the husband has alleged cruelty, then you are trying to prove cruelty committed by you by filing an affidavit.
What happened?
So have you examined that law? That direct case is on this point is there.
Wife has no role to.
ଆପଣଙ୍କର ଶୁଣନ୍ତୁ, ଆପଣଙ୍କ objective, ଆପଣଙ୍କର achieve କଣ କରିବାକୁ ଚାହୁଁଛନ୍ତି ଏବଂ ଆପଣଙ୍କର legal strategy are completely contradictory to each other.
My submission, my lord, with respectful submission, my WS is my pleadings. And in my pleadings, I may make an issue. The husband has an adulterous attitude.
ସେଥିପାଇଁ ଡିଫେଣ୍ଡାଣ୍ଟ କରାଯାଏନି ସେଥିରେ ୱିଟନେସ୍ ଆଡ୍ୟୁସ୍ କରାଯିବ
Witness ଦେବେନି ମ୍ୟାଡାମ ସାର୍ ଦେବେନି ତାଙ୍କୁ witness
ଦେବେନି ତାହେଲେ ସେଇଟା ତ ଆପଣ ସେଇଟା ତ କୋର୍ଟ ଆପଣଙ୍କୁ ହେଲ୍ପ କରିବନି ସେଟା ସିପିସି ହେଲ୍ପ କରିଥିଲେ ସିପିସି ଆପଣଙ୍କୁ ହେଲ୍ପ କରିପାରିବ
ସେ ତ କେବେ ବି କରିବେନି ଏଭିଡେନ୍ସ ସିଷ୍ଟର ଇନ୍ ଲ'ର ତ ହାଉ କୁଡ୍ ଦି ଇଶ୍ୟୁ ୱିଲ୍ ବି ସେଟେଲ୍
ଆପଣ ସର୍ଭିସ ଲ ତ କରୁଥିବେ ମାଲାଫିଡେ ଇଜ ଏ କମନ ଗ୍ରାଉଣ୍ଡ ଯୋଉଟା କି ଆପଣ ସର୍ଭିସ ଲ ପଢା ହେଲା ମାଲାଫିଡେ ଇଜ ମୋଷ୍ଟ ଇଜି ଟୁ ଆଲେଜ ଆଣ୍ଡ ଇମ୍ପସିବଲ ଟୁ ପ୍ରୁଭ ଆପଣ ସେଟା କରୁଛନ୍ତି କାହିଁକି so that is how you are creating evidence against yourself the husband's ground of you being cruel is you are creating evidence making false allegations itself is a cruelty
I am not making false allegations
अरे मते कोन कहउछोंती मु कोन एडजुडिकेटर ना कोन आपण बुझी पर नान ताले कोन लीगल कॉन्सेप्ट मु आपण बुझो इट इज जस्ट नाउ बिकम ए लॉ क्लास नाउ you are proving that you are cruel to your husband by because you are making allegation against him
yes
so you have to prove it
how could I sir prove unless
sir the written statement re again sorry
If you cannot prove, why
you should not
always recording evidence of the person
so आपण से तुरंतु आपण आपण तापर कहबे जे हम भगवान को डाकिया कारण भगवान जानछथि बुझपछथि God knows everything so भगवान को करियबो कि करियबो
unless recording evidence of the necessary parties the alleged allegations
sir सेटा आपण एक पर्यंत कोटी भी केस ला देखले नि the court will come to the aid of parties to adduce evidence आपण जो बटन 10-3 पढिले 10-2 पढिले first of all you have to show me that आपनकर 1-3 10-2 is exception to 1-3 it is a clear case of 1-3 but a non-gender of necessary he should give no one else in some dominus litis he is seeking divorce against you you want addition of an opposite party against whom he doesn't have a claim now check the Hindu Marriage Act देखो सेठी में सर्विस लॉ रे कोइ छै when you are alleging malafide be careful because if you pitch it up that high that alleging malafide against the authority even in tender contract matters because you cannot prove it
Lordship, if I may interrupt for
my
1
respectful submission in one line
अपन 13A देखो 13B टा 13A has a significant consequence 13 capital A पहले This copy you can read 13A पढ़ो आइए
13(1) आइए
13 dash capital A in any proceeding under this act on a petition for dissolution of marriage by a decree of divorce except insofar as the petition is founded on the grounds mentioned in clauses 2, 6, 7 of subsection 1 of section 13 the court may if it considers it just to do so having regard to the circumstances of the case pass instead of decree for judicial separation that is one of your choices About 21 is very significant also 21 or
Sir, 23A.
23A
Yes, sir.
23 capital A देखो and read 23 capital नला आपण पढो
Relief for respondent in divorce and other proceedings. In any proceeding for divorce or judicial separation or restitution of conjugal rights, the respondent may not only oppose the relief sought on the ground of petitioner's adultery, cruelty, or desertion, but also make a counterclaim for any relief under this act on the ground that.
Say 23A रे ही in fact this is a आपण adultery ground नेबे 23A रे ही नहीं परिबे आपण निज you are chopping up the branch where you are sitting by making an allegation which will what Mr. Lenka is saying that if you cannot also substantiate a allegation you should be very careful in not filing an affidavit because now there is a clear pronouncement of the Supreme Court that making false allegation is a cruelty I think Mr. Das was arguing that matter.
Unless,
I mean, it how manifest. It how manifest the same thing in the division bench. Right now I remember looking at you. Yes. The citation of mone peko chesta korthil, then I reached my memory reached you. So the problem is that you must understand. It is better. I can very well say that no case is made out. It's your choice, but you must understand all this discussion is because it's a matrimonial cause. Two souls are fighting it out.
May help.
Yes, please.
But in fact,
Senior advocate are always they are not identified with any brief.
If the respondent or defendant in a Section 13 application, doesn't matter whether the plaintiff is the husband or the wife. If the defendant raises a plea of adultery against the plaintiff, that itself becomes a cruelty, as that is rightly found for my lads. But what my lad friend is arguing, my lad, he wants to implead, my lad, the lady.
But what is the 23 application?
23 application is a counter. It's a counterclaim.
Counterclaim.
It's a counter.
So no, Mr. Das, actually, that is a very tricky situation.
Yes.
What she wants, she wants registering the, she's not agreeable for divorce.
Exactly. So
that is the problem.
Blowing hot and cold.
That is the problem.
The two things.
So that was my first question. That was my first question.
But here, as far as my learned friend is concerned, Lordship sees under Order 1, there are two provisions. One is impleadment, another is as an intervener.
Correct.
Order 1, Rule 10 is impleadment. Order 1, Rule 8, capital A is intervener.
Yes.
And the intervener need not be made a party, but the principle with regard to who would be the intervener, who would be impleaded ballot is same. Necessary party or proper party. Necessary party is whose presence is required for the purpose of the adjudication, of drawing a decree. Proper party, it is just like a catalyst, which will assist the Honorable Court to arrive at a judgment. And in this case, let me, after hearing now supposing a Lordship allows the wife to be impleaded as a party, the adulterous lady, who is instrumental to make the life adulterous, as a party.
Party obviously as a defendant.
No, so yes, supposing a Lordship allows.
She can. So now
what I'm saying
now the problem is.
I'm Lordship.
In husbands. No, I got your point. So
what I'm saying is I'm going a step ahead.
Yes.
Supposing the application is allowed to implead her as a party. Allowed. He doesn't appear. What will happen? Same thing. Now it is allowed, but she will not appear. The best thing as has fallen from my lord, either 23A or to file an application and to make her a witness. In order to prove adultery, he has to file an application.
In fact, I was tempted to answer that because the Lord Counsel is saying that she will appear, she will not appear. That's a because but that is a different issue altogether.
Yes,
that is a issue different altogether.
Good. But the
way you are moving, the way you have been moving, you must understand the priority of your client is that she wants to sustain the marriage.
Yes.
So if that is there, then she has to be very careful.
Yes. So in order to sustain the marriage,
this approach is much more belligerent than simply denying the allegation.
Yes.
Sir, in your written statement, you will simply say that I am not cruel. I have not deserted. What is the best defense in case of cruelty or desertion? That for the circumstances beyond my control, I have been compelled to stay away. That much. So that satisfies the resistance to the 13(1) application. But upon the label ko nahi already bartaman. And it is impossible actually.
Normally,
adultery, in fact, in certain cases, Justice Sinha was not agreeing that the adulterer will be a party. What Odisha High Court has amended, I think in the early 60s it has been amended, or late 59 or 60 it has been amended. And suppose you want to have a counterclaim, but as you are saying, you do not have a counterclaim, you simply want to register it.
Basically, we not counterclaim is lost for the purpose of getting back the property, which are given as type of man.
Sridhan ଆପଣ ସେଥିରେ 23 ରେ ବି ହେଇପାରିବ।
Yes.
ଆଉ ଗୋଟେ ବି ଅଛି Sridhan ପାଇଁ, but ଆପଣ ସେତେ ଗୋଟେ ଭାବୁ ନାହାନ୍ତି।
Nah, because I have till date also, I have not, the wife never ever filed any registered complaint, FIR against her husband.
ଆପଣ ତାହେଲେ କାହିଁକି 13(1) କୁ ଏମିତି କାହିଁ କରୁଛନ୍ତି?
ଏଇଟା କଲେ against you.
ଆପଣ 13(1) ଟାକୁ ଯାହା କଲେଣି ବର୍ତ୍ତମାନ ତାଙ୍କର 13(1) ପିଟିସନ ଆପଣ ତାକୁ ରେଜିଷ୍ଟର କରିବେ ସିମ୍ପଲି and you will time is a great healing factor ଆପଣ 13(1) ରେଜିଷ୍ଟର କଲେ ମ୍ୟାଟର ପେଣ୍ଡିଂ ରହିଲା କଣ ହେଇପାରେ କେତେବେଳେ କଣ ହବ it's difficult and ତାପରେ ଆଉ ଗୋଟେ ଜିନିଷ ଆପଣଙ୍କର she might be having a real apprehension or maybe a genuine that no one knows ଭଗବାନ ଜାଣନ୍ତି କଣ exactly ହେଇଛି ଆପଣ ଯେତେବେଳେ ତାକୁ when you are giving a color of law and bringing into the four corners of a proceeding it will have a consequence.
What happens in after WS when I filed my evidence they put questions on such paragraphs at that moment I am helpless.
ଆପଣ ସେ ଭୁଲଟା କରିଛନ୍ତି I should not have told them. ମୁଁ ତ ଆପଣଙ୍କୁ assist କରୁଛି in fact apart from Mr. Das I started assisting you. Mr. Das has picked it up very well. So, I mean court's intention in the sense. Me not as an individual, but ଆପଣ ଯୋଉଟା ଆପଣ ସେଥି ପଛରେ ଆପଣ ଚାହୁଁଛନ୍ତି କଣ ଆପଣ କହୁଛନ୍ତି ଯେ I want to sustain the marriage. ଆପଣ ତ ଗୋଟେ ରୁ ଗୋଟେ ପରେ ଗୋଟେ ଜିନିଷଟାକୁ ଯୋଉଟା you have to be very careful actually.
That observation may be passed below 23.
No, observation ସେଟା କେବେ ନିଅନ୍ତୁନି. Never when you are sustaining something when addressing a legal right, if you say that then Ms. Kabi will argue or some lawyer will argue, I mean that the court never granted this liberty. Upon the situation can create karibe. But the simply upon 23 is not an option for you. When you want to simply register the divorce. What you are saying if that is correct. Upon 23 रे कौन टा करिवे? Upon 23 पे अपन किछ करिवार नहीं. Upon 13 रे चाहूचंती कि upon जदि 13 चाहूचंती your 23 application can be a 13(1) application on ground of desertion, cruelty, adultery. In fact, interestingly, 23A mentions the word adultery. I was not conscious of that. When I suggested about showing you 23A, I was not conscious that 23A itself contains the word adultery. Because the statute itself predicates. The legislature, when the draftsman, they have predicted such kind of a situation. But upon the chahunanti, upon 13(1) khali register chahun. So upon your endeavor should be 13(1) re upon against jetik allegation achis, tepi chhad diyo. That you have to disprove or you register that those kind of.
That's the issue. Mediation
Yes, Mr. Kabi.
Your Lordship, I strongly
patient enough to hear all of us. Yes. What
yes, Your Lordship. Your Lordship, first of all, the prayer may be perused. They have pleaded to ask her as a plaintiff, not a defendant also. The prayer. First.
Still worse. About the plaintiff can be
Plaintiff implead kariya.
So you are conscious. I mean, not worse.
Very conscious.
Exactly. You are conscious that since you are not claiming any relief against the lady, the particular lady, so you cannot implead her as a defendant. That question I asked you.
That is very grey area. Whether the defendant has a case, what due to the...
Then if we interpret like that, then there will be only one suit ever. गोटे सुट चलिबो सबड सब केस हे जो सर जीवो
against
cause of action set में very clearly लिखा है अपन जो 10(1) देखिए इज वेरी क्लियर
against whom the wife sought for alleged allegations the plaintiff can never ever made him a party as a defendant number 2 the only option
अपन 23 is the
only
option is the answer अपन यदि से मैटर जिबे you want to make allegations against the husband 23 dash capital A is the only answer अपन चेटा क्वेश्चन you want to sustain the marriage.
Your Lordship, along with that, the matter before the court below was posted. The written statement was filed way back in the year 2023. The evidence and this Your Lordship, the petitioner has very cunningly not disclosed in her petition, in the writ petition. This is her 5th case before this honorable court, and she has filed 4 cases. She is just filing a petition before the court below that gets rejected. She comes to High Court.
Ms. Kavi, when the lawyers will say that we will not file cases, that would happen. So that,
Your Lordship,
I mean,
she has not disclosed also in this writ petition that
No,
she has already.
that need not be.
No,
That,
in say,
Along with that, in
and,
this,
and in matrimonial matters, don't use this language very cunningly and all that, because you are a lawyer. You are above all this. What
Yes.
is happening?
in 125
Your Lordship, in
lines,
this,
the
particularly,
same husband Miller, please wait. The same husband Miller.
She never
He has
responded.
not
2 lakhs area due.
She never
Now they're
responded.
submitting.
She was patiently listening you, so allow her.
Your Lordship, the matter was posted way back in the year 2023 for evidence. And after, there were 2 last chance also given in 2025. And till then also, she did not adduce her evidence. If she is supposed to, she is just filing petitions after petitions to delay the
might not be hearing this court, but every day we are finding that to drag the proceeding, TRPC and RPFM is the strategy.
Yes, Your Lordship. Your Lordship was rightly saying it
So,
for some
in
time
fact,
once.
we are breathing on their neck that you dispose of matrimonial cases. Supreme Court is breathing on the family judges that why you are keeping the matters pending. 125 and 24 matter and section 18 maintenance, why the matters are kept pending. We are discussing in our administrative side in-house always. And we are going at any length to tell the court that please don't keep these matters pending. But whenever now a RPFM is filed, after 5 years, defect is not removed. The purpose is perhaps only to drag the matter.
Your Lordship, I am the petitioner before the court below. Your Lordship has everything has been already discussed, and that was my only point before the court below as well, for which this petition was rejected.
No, the court doesn't have power actually.
Yes, Your Lordship.
Court doesn't have power.
I bow down. And if she was
regarding summons to witness, that is another chapter.
That-
you have to examine that carefully.
That may be the observation.
That's why I'm suggesting you, because after that something can happen also. So, but you have to be very careful, because you have to tread very carefully, because the wife's intention is to sustain the matrimony. झगड़ा हुए, misunderstanding हुए, बहुत जिनिस माने allegations, counter allegations ही पारे. But still, marriage as an institution has some different meaning and connotations also.
For this reason, my lord.
It is a sacrament. In our society, it's a sacrament. That why it has been elevated to that level.
For this reason, my lord, the wife till date never misutilized the law like 498A, DB case.
Misutilization is
now one should. Otherwise, very common things.
There was
to file
no
a
ground for
498A
her to
case.
file.
Other criminal cases.
There was no
They are
ground
sustaining
for
for the marriage. Now the husband has
Rabindran cited this honest judge, and now Justice Pancholi is there.
Yes.
She should not actually.
She
Not
should not.
that she has done something great by not filing for cases.
because
one
she's
after
a law graduate. Wife is a law graduate. She's no
She's
also.
a lawyer. She's an advocate. She's present before this court.
CPC तांकर ठीक रे like Mr. Agarwal taught me, so CPC पढ़े थे लेता था.
Now the question remains the issues which has been unsettled.
So the
unless recording evidence of the intervener petition.
ଆପଣ ଦେଖନ୍ତୁ ଆପଣ ଯଦି ସେଟା ଚାହୁଁଛନ୍ତି seriously prosecute କରିବେ, this you are just banging your head on a wall. CPC doesn't contemplate such situation, the addition of a plaintiff. It is almost impossible, because then the first ground is that it is a non-gender necessary party, so that is how the plaintiff should be come into picture. The language, 10-1 language you have to read. So it is not there.
Plaintiff never says.
So the judgment
wishes
will be that the decision of the learned trial court is correct. That one. Beyond that, whatever you decide and you do, hearing concluded.
Your Lordship, my
I may
humble prayer last
with a liberty.
there was an order passed by this Honorable Court on dated 7/3/2025 in WPC number 7784 of 24, which was filed by the present petitioner. In that case, Your Lordship, in the last para, it was observed that she came before this court for some other purpose, in which it was mentioned, needless to say, the learned trial court shall make all endeavor to dispose of the case at the earliest. And it was the order of 7/3/2025. So 1 year, more than a year has passed, and the case lies at the same stage. She is not adducing her evidence before the court below. So my humble prayer is
44, the Supreme Court has found, the Honorable Justice Binder.
Yes.
So we have reached 37. So that saga will continue.
My humble prayer is
But
that
the
time
difference
for
is that
disclosure.
in fact, the Honorable Apex Court has observed.
Yes, Raj.
They have cluttered the board of the courts by filing 44 cases against each other 10,000 cost each, and exercising 142, the marriage is dissolved. My experience is 37.
My humble is to fix a time period.
Even I remember the
My lord.
Lord Council also.
They have
Yes.
to 2 lakhs.
So now in your case, there are 10, 12 cases. And
Yes.
every time time is fixed, the counter strategy is that you file another application for recall of a witness. So we do not know what. I mean, these are innovations of law.
Your Lordship, my humble prayer is to fix up the time at least, because
Applicability of CPC is concerned.
They are
It's not a
suppressing-
commercial court act case.
yes, Your Lordship.
Commercial court act maybe what day will come when commercial court act principles will apply to all cases when there is dragging of the matter. So we have already
My lord, they have 2 lakhs arrear dues.
Time.
They have admittedly 2 lakhs arrear dues. I never opted to file a petition for struck down of the pleadings.
She has already filed and it was rejected.
This is not a 125(3) or execution petition.
That is my bona fideness.
Whatever. You have to, if you are so bona fide, don't spoil. I mean, it is so fragile. The relationship is so fragile that you are bringing in now filing a petition that alleging against a particular adultery against a particular person. You must understand that your objective should, be in sync with your action.
With a liberty, my lord, with 2-3 permission, the observations let her as an evidence that must
No.
reflected.
Move. I can't become the family court.
So unless that issue,
Sir, what would happen in the court, sir?
Again, my lord,
I may not understand any law, but this kind of fundamental error I will not make.
again,
That
file a
in a
petition.
trial, I will start directing that so and so will lead evidence and X will not lead evidence. That is none of the business. The CPC is very clear. It covers almost all aspects. What would happen? That's a different thing.
Lordship, my humble prayer just to fix up a time for disposal of the
No.
case.
Read the Constitution bench. Have you read Para 43? Allahabad Bar Association.
I'll read. Because there was already
Expressed
direction by
grave
this
concern.
court.
Next, after that, Justice Oak's observation. The High Court, despite the direction of the observation of the Constitutional Court, should not fix time. It is fixing time every day.
Only then expeditiously.
Asian resurfacing has been revisited in that Constitution bench. There, Para 43, it says that courts will not, because the reason being, this is not the CP, this is a CP of 2021. You will find in Bhubaneswar, CP of 2015 is still pending. That the Supreme Court has expressed concern that no constitutional court should express.
Your Lordship, the matter is pending for respondent's evidence. So after this, only
We
argument
say
is there.
that the parties will cooperate. That
Miller, what
Explain
happened?
for expeditions.
Please, what there?
we have already
In the year
we don't
2020,
have a bench at 2, but so there will be some
Yes,
mentions.
yes.
We have to accommodate that.
2020 marriage, 2021 divorce समाज पर divorce file করছেন। Attitude suspicious.
Judgment in today's date, the order is not being interfered with. Yes. You cooperate if you want.
My lord, that issue is unsettled unless even if divorce has been ordered. At this, my lord, that
The issue
issue
is never framed.
which has been raised by the wife, still then I am.
Mr. Rotha, that is hypothesis. If you want, the question is that if you want, then you have a method in 23A or even for judicial separation 13A, that is there. Bhagavad Prasad Rotha for the petitioner, Ms. Akanksha Kabi for the opposite side. Item 16 Lekontu. Mr. Sanjit Mahanti, Senior Counsel, along with Advocate, along with Mr. Rakesh Sharma for the petitioner. Mr. 16, Mr. Lenka.
Yes.
DN Lenka for the
State.
for the opposite parties, all opposite parties. The matter is listed for hearing under the heading for admission. On consent, adjourned to the week to be listed in the week commencing listed for admission in the week commencing 11/5/2026. Interim order dated 23/11, Mr. Lenka.
Yes, sir.
23/11/2016 shall continue till the next date of hearing. 17, Mr. Das, your matter, it will be date, it will come on a
There
date.
is no state, it's not the gratuity. They have not reduced drastically the amount to be paid. despite the specific provision made in the Act 1981 Act, and the recent judgment of Supreme Court has come in 2025 with regard to that. A case is squarely covered by the recent judgment. Either they have to pay to the non-government college teachers.
Kindly give that reference to Mr. Lenka.
I'll give you that reference.
Yes. 17 out a date got you.
Okay.
I'm not marking any order. I mean, not recording any order, but it should be posted to a date. Kebe karantu. Yes. Then items 18 to 23.
Item 18, my lord.
Yes, Mr.
And for the opposite party. All opposite parties.
18 ଆପଣ ଅଛନ୍ତି 18 ଟା ପୋଷ୍ଟ କରନ୍ତୁ ଡେଟ୍ ଚାହୁଁଛନ୍ତି ଡେଟ୍ କରନ୍ତୁ
Item 20, there is an interim order.
20
My lord. I'm for the
Mr. Tripathi is there.
I am for the respondent, my lord.
Just let me open the file. Order कौन थिला कहि परिबे 495.
My lord, the order is interim order. Stay of the CP, man.
But that I'm not touching. I mean, if it is an adjournment order, then it becomes difficult because the date is specified. Beyond item 16, I'm not touching any order. Wherever interim order is there, it remains untouched. Right. 19, Mr. Mishra, any other date it has to come because today there is possibility of time. 2 p.m. This bench is not available. So.
ମୁଁ ବୁଝିଲି ଆଜ୍ଞା ଗୋଟେ ପାଖ ଦିନକୁ ଯଦି ମୋ ଅନୁରୋଧ ରଖିପାରିବେ
ସବୁଠୁ ପାଖ ତ ରଖୁଛି
ଆଜ୍ଞା
ସବୁଠୁ ପାଖ କାହିଁକି ନା ରଖିବାଟା ସହଜ ଆକ୍ଚୁଆଲି କିନ୍ତୁ
ମୁଁ
ଛୁଇଁବାଟା କଷ୍ଟ
ମୁଁ ବୁଝୁଛି
ମିଷ୍ଟର ପଟ୍ଟନାୟକ ସରି ମିଷ୍ଟର ମିଶ୍ର ଗୋଟେ ଡେଟ୍ କଲେ 19 ୱିକ୍ କମେନ୍ସିଂ 11/5
ଆଉ ଟିକେ ପାଖକୁ
ସାର୍ ତା ପାଖରୁ ଆକ୍ଚୁଆଲି
ମୋ ପିଲାମାନଙ୍କୁ ପଢେଇ ପାରୁନି ଜମିଟା ବିକ୍ରି କଲେ ମୁଁ
ସେ ଆଜ୍ଞା up to 29/4 he has already crossed 300
29 ପରେ ଗୋଟେ ଦିନକୁ
ସେଇଥିପାଇଁ ତ 29/4 ପରେ ମୁଁ ଲାଷ୍ଟ ଦେଖୁଥିଲି ସେ ଆପଣ ଦେଖନ୍ତୁ 29/4 ୱିକ୍ ପର୍ଯ୍ୟନ୍ତ
ହଁ ଠିକ ଅଛି
ସେ ରଖିଛନ୍ତି
ବୋର୍ଡ ନାହିଁ
cross 300
ଖାଲି ବୋର୍ଡରେ ଆସିଲେ କିଛି ଲାଭ ନାହିଁ
exactly so that is the reason ଖାଲି ଆଡ୍ କଲେ ଆଜ୍ଞା ସବୁଦିନ ଗୋଟେ ଦିନରେ ବି 100ଟା ଲିଷ୍ଟ କରି ହବ
ଆଜ୍ଞା ମୁଁ ନେବି ଚାନ୍ସ ସେଇଦିନ
Item 20, my lord, may be.
ୱିକ୍ କମେନ୍ସିଂ ନ କରି ଗୋଟେ ଡେଟ୍ କରିଦେଲେ
ସେଥିରେ ଅଛି ଅସୁବିଧା ଆପଣଙ୍କର ଲିଷ୍ଟିଂ ପ୍ରୋବ୍ଲେମ ହେଇଯିବ once there is a judicial order they cannot adjust the matter
ଆମେ ଯାଇ ସେଠି ଗୋଳେଇଲା ବେଳକୁ ବହୁତ ପ୍ରୋବ୍ଲେମ ହଉଛି
ନା କରିଦେ ସେଇଟାକୁ ସେଇଥିପାଇଁ ତ ୱିକ୍ କମେନ୍ସିଂ କରିଦିଆଗଲା ଧରନ୍ତୁ 40ଟା ଆସୁଛି 50ଟା ମ୍ୟାଟର ରହିଯାଇଛି ଆଡଜଷ୍ଟ କରି ହଉନି ତେଣୁ ସେଇଟା ଗୋଟେ ପ୍ରୋବ୍ଲେମ ହଉଛି
ଆମର ସାର୍ ମାନେ କହୁଛନ୍ତି ଆଜ୍ଞା ୱିକ୍ କମେନ୍ସିଂ କରୁଛନ୍ତି ଆମକୁ ବହୁତ ଗୋଳେଇବାକୁ ପଡୁଛି
ନାଇଁ ଆଇ ଥିଙ୍କ ଇଟ୍ ହାଜ ୱାର୍କ ଧରନ୍ତୁ ଯୋଉ 2 ତାରିଖରେ କୋର୍ଟ ହେଲାନି ସେଇଟା ଆପଣଙ୍କର ସେଥିପାଇଁ 100 ହେଇଗଲା କେମିତି
ସାର୍ ଥାଉ ମୋର
ସେଇଟା ହଉଛି କଥା
In
that's
item,
the purpose actually there is some method in the madness
ସାର୍
in item 20, my lord,
yes 20 ଆପଣ ଗୋଟେ ଡେଟ୍ ନିଅନ୍ତୁ
my lord, the short date, my
ସର୍ଟେଜ ପସିବିଲିଟି ଦିଆଯାଉଛି ନା
Aye.
ଆପଣଙ୍କର ଏଇ ଓଡିଶା ହାଇକୋର୍ଟରେ ହିଁ ଏତେ ସର୍ଟ ଡେଟ୍ ଆକ୍ଚୁଆଲି ଆପଣ ଅନ୍ୟ ହାଇକୋର୍ଟ ଦେଖିବେ ଦିଲ୍ଲୀ ବମ୍ବେ 2-3 ମାସ ଆଗରୁ କି ଡେଟ୍ କରନ୍ତି ବିକଜ ଇଟ୍ ବିକମ୍ସ ଏ ପ୍ରୋବ୍ଲେମ ଆକ୍ଚୁଆଲି ଆଉ ଯୋଉମାନେ ଏଫିସିଏଣ୍ଟ ଇନ୍ ଲିଷ୍ଟିଂ କେବଳ ତାଙ୍କ ମ୍ୟାଟର ହିଁ ରହିବ ଅନ୍ୟମାନଙ୍କ ମ୍ୟାଟର ସ୍ୱରୂପ ମ୍ୟାଟର ଖାଲି ରହିବ
এটা জমা উঠুনଥିଲା স্যার ବହୁତ କଷ୍ଟ କରି এটা ଉଠିଛି
ସେଇଟା ତ କ୍ରେଡିଟ୍ ଗୋସ୍ ଟୁ ହିମ୍ ଅଲସୋ ହି ଇଜ ମ୍ୟାନେଜିଂ ଦ୍ୟାଟ୍ ୱେ ଆଟଲିଷ୍ଟ ଏକ୍ଜିଷ୍ଟ ହେଇପାରୁଛି Yes, Mr. Patnaik, your matter will be taken up at 2.
Yes, sir.
Okay, ठीक है. I'll come back since it is already late, so I'll come and take up. Mr. Surup, only for that for the personal appearance.
24 my lord.
Again?
24 of this.
कहले नहीं अपन.
24 चार.
केबे डेट केबे कलो? आफ्टर नोटिस कौन नहीं 24 There are so many orders matter which have to be heard actually. I don't suppose.
Welcome to
28 minutes.
से डेट कर देबे. सब गुडा को एडजस्ट हे जिवो. 28 आइटम 28 अपन चाहो जदी डेट कर दियौ तो मिस्टर.
20 हमर 11/5.
So तारीख.
Welcome to 11/5.
11. So that personal appearance matter that is item
27.
27 I'll take up after I return because already notice no special notice
Special.
The petition is listed in the supplementary list today. The bench was available. Oh. The bench was available till 1:15. Was available for the first half before lunch. Stop. The matter was mentioned by the learned counsel for the opposite party at the beginning of the day's proceeding. As the bench was, as it was notified in the cause list that the bench shall not function after 2 p.m. In the proceeding before lunch, the petitioner appearing in person also mentioned the matter at 1:45 to be taken up. Stop. Accordingly, the matter is listed in the special notice and taken up at 2:30 p.m. Yes, Mr. Patnaik.
Sir, thank you, sir.
Say there was a direction Mr. Swarup was referring to affidavit paragraph. कोटा affidavit तो आपने थी
order dated 12/3/24 रे
12/3/24
point order point number 12 admission process shall be completed by 12/3/24. It was done by 7/3/24 again, but on the last date I could not give as she was ill, so I could not take instruction. I have filed an affidavit with documents by taking his receipt, and I will file it registry. I have the copy now.
Okay, the learned counsel for the opposite party, Mr. Swarup, submits that it was refers to the order dated 12/3/2026. Paragraph, paragraph 12. Paragraph 12. Paragraph 12, which reflected thus. Paragraph 12 quote कर दिया. It is submitted that. अपना केफे कोचिंग एडमिशन है
7/3/24.
The admission of the child in the KIT International School that was discussed in the said order dated 12/3/2026 at length had already taken place on 7/3/2026. He submits that affidavit dated
but it was done on 6/4/26.
Dated 6/4/26 has been prepared on behalf of the opposite party, copy of which is served today in court. Copy of which is served on the learned served on the petitioner appearing in person in court today. Now, regarding the order impugned in this application is 9/5/2025. That is passed in that proceeding before the civil judge, the family judge, family court through Bhubaneswar. That 9/5 order is that page.
Sir, one. Sir, page
Annexure
36.
one.
Sir,
Annexure
I will tell you.
Annexure 1 page, my lord.
Sir, Annexure 1, page 57.
57.
Yes, sir.
So, this father guardian in the school admission, his name has been mentioned.
Yes, he is.
No, sir. I strongly dispute this because when I asked this specific question to the mother, she
No, don't go by you because there is more likelihood of you fighting over that issue.
Okay.
The question is not regarding the mother saying or not saying. In KIT International School, where the child has taken admission,
Yes, sir.
your name has been mentioned as the father.
I am not sure because I do not
Yes,
have any
okay.
access
My
to
lord,
the.
Just what's
My lord, without mentioning the name of father, they
it cannot be.
cannot
I mean that is how I was thinking in that place, those lines also. It is submitted by the learned counsel for the opposite party that name of the father, which is essential for getting admission to school, has been mentioned in the records of the KIT International School where the child has got admitted on the author date that 5 7/3/2026. अच्छा. Regarding the first petition that was filed, though not numbered, before the learned judge family court -2, as reflected in the order dated 9/5/2025 at internal pages 2, 3 of the said order into bracket pages 57 and 57, 58 of the writ petition of the petition bracket closed. It is observed that regarding the admission of the child to a school and mentioning of the father's name in the school records, no further issue survives to be adjudicated. Regarding that pick up his child from school and after school hours drop him back at his mother's home at Jagamara. So regarding that, the child is now accompanying the father.
So child is now going to the school, which is in KIT International School. So the child is coming to the home of the respondent at 4:30 around that. So since I am also staying in Old Town, it may not be possible for me to pick up because when I had filed this application, I had kept in mind that they will find a school which is close by to both our residents, like Eurokid Surjanagar. So what I am doing is now that in the afternoon, in his playtime only, I am going and visiting him in the 5:15 to 6:15 time.
Regarding the child and the father petitioner spending time together after school hours, it was stated by the petitioner that he, due to the distance from his place of residence in the Old Town, you stay in Old Town?
Yes, sir. Near Lingraj Temple.
In Old Town, to the school, that is KIT International School, that is at Chandagar.
On the Patiya.
At Patiya. He cannot travel the distance to visit the child at school, but he spends time with the child after the child returns home around 5:15 p.m.
From 5:15 to 6.
Around 5 p.m. till 6:15 p.m.
Yes.
This aspect is noted in the context of the second petition that was filed before the Lord Judge Family Court to Bhubaneswar. regarding the finding out of a suitable school for the child, which was subject matter in the third petition. That was not numbered, but reflected in the internal page 4 of the order passed by the learned judge, Family Code 2. The situation is happy for both the parents. The child has taken admission to a school which will take care of the special needs of the child, as the school has itself shown interest and committed for taking care of the child. Sentence complete है ना? As far as the third petition, status, third report. It आराम तक पा रहा हो regarding subject matter of the third petition that was filed before the report 2. Internal page 4. The situation is happy now upon that. Custody petition is pending there.
Yes, yes, sir.
The custody petition, you have to what you can do, you can file a properly constituted petition.
Yes, sir.
Don't I mean this, because there the subject is very nuanced.
Yes, sir.
So you have to have a proper application. A person with and some study in law has to prepare
Yes,
it,
sir.
and it has to be in a particular provision. Regarding the fourth petition.
Sir, with your permission, I would like to submit few things. Sir, in the interim application, I have requested for, I have prayed for weekend custody. While I understand that the custody petition is pending before the family court, at the same time, there are cases where in the interim application also, fathers do file interim custody, weekend custody and all, and some courts are in the High Court of Karnataka and the High Court of Bombay, which was also upheld by the Supreme Court of India, has been accepted. So I am requesting that in the case where the mother is not staying with the child, it should be entertained and given a fresh consideration by this court, which is already aware of most of the situation.
No, difficult. Without adjudication on merits, this court lacks jurisdiction.
Sir, but I can give you
Karnataka High Court and Gujarat High Courts, maybe you are correct, they are finding, but the facts may be different.
No, sir,
And
it is very similar.
definitely, the original jurisdiction doesn't lie with the High Court.
Sir, may I please submit them in this, can you please go to the page number 60 of this in the writ petition, main petition?
I'm at page 60.
Okay, sir, in that it is written that admittedly the custody of the child will be decided after taking the evidence from both the sides. At present, the child is under the care and custody of the mother. I am genuinely disputing that because
But
today.
the problem is that you are trying to chop off the branch where you are sitting. When the court says that it will be decided after appreciating evidence, that is not against you.
No.
So you have to be patient there.
So, sir,
so in a hurry to have interim custody, you are damaging your own case. Because perhaps you do not understand the process involved. It is nothing like you are offering pizza like a counter and go, it happens. So if the court wants to see and hear evidence, there is nothing against you.
I am not saying
So,
that
so,
the
so
case-
if you are, if, because this observation is not that it is a determination. What you are reading, as if it is a determination by the court that is in the custody of the child in the weekend. So you may say that it is not 24/7 custody, mother
Yes.
is not having custody. All those things are not besides the issue.
No, sir.
Because your approach is like kind of straight away you are trying to, start hitting the score. In cricket parlance, you straight away go and start hitting.
No,
So
sir. We
it
are
is not
trying to-
that kind of a process.
Sir,
You have to be patient with the process. When the court says that no High Court, maybe Gujarat High Court can do it, but this High Court, or as you are saying, you may expect that, but most of the High Courts will not interfere, because in fact it is a matter of evidence.
So the only thing is,
And for this court to proceed without appreciating without the trial court appreciating the evidence is not possible.
Sir,
Also,
there are only two submissions that I want to make. The trial court in this case, in page number 60, had highlighted that the custody of the child is
no,
with
it has
the
not
mother.
highlighted.
That
You are.
particular, sir, at
You
present,
see, I can understand. I can explain it to you. The court is saying regarding transfer of custody. There is a concept of handing over the custody to a particular for a child, because the court is overcautious when the child is small. And suppose not exactly transfer, it is change of custody, you can say. Maybe for a day or for a weekend, all these things.
sir, here,
So you can always move for visitation and contact rights. It's no difficult.
sir, in my case, since my son is having ADHD, and it is in his best interest to spend more time with me because the mother specifically is not staying here. I want to highlight here the information.
Right now, I have to reject your prayer.
Okay, sir.
Right now, you must understand. Unwittingly, you are chopping up the branch where you are sitting.
Okay.
You should not invite this court to observe anything which has not been determined by the court.
Okay.
You have a perception. That the trial court has determined certain things. For your satisfaction, I will ask this question.
Yes, sir.
Which I should not ask to Mr. Swaroop. Mr. Swaroop, being a counsel for the opposite party, I should not ask you this question. I am conscious, because I cannot ask you to commit something. But according to you, being a lawyer, has the court determined any issue?
Issue as you
That the mother is having custody or not? All these things, those aspects, the court.
No, it's he has to adduce evidence, and it's pending since last 2 to 3 years.
Correct. So in that context, the observation is made. The court is saying that if the child is now staying with the mother, you are saying that child doesn't stay with the mother.
Mother is not staying.
It can't be a matter of speech it's not a debate competition.
Okay.
You must understand that. When the appropriate time comes, you want to challenge the custody, what I have told you, that you must understand it's a nuanced subject. It's not that easy subject for anyone to argue. Say, so that is a very good statement in a drawing room discussion, but may not be necessary. Then working mothers will never have any custody.
Sir, I am not.
You must
saying-
understand.
Sir, I am not.
No, I'm not asking you to answer that. If what you are saying, you are thinking that because the court has thought that the child stays, the child does not stay because the mother is not staying, could be. But please wait for that time to come so that you adduce evidence. Let the court form its opinion based on the evidence. And for that, don't file so many petitions which are not structured. Whatever you are looking at in a court process, it is largely structured. Hardly you find anything not structured. You have to. I asked you on the first date that whether you are referring to any provision. Why? Because every court has to look at a provision and the scope of that.
Yes.
So it is not that kind of a general, that fluid. You cannot say it is indeterminate and fluid. It's not that kind of a situation. So you have to be a little more patient and don't take exception to every line the court has said. So you might be thinking that the court has said something wrong because the mother doesn't say, but actually the court is not intending that. You must understand the context, because if you have to read from page 60 para, second subpara so far as another petition is concerned. So court is discussing that. And visitation rights have been already allowed to you.
Yes.
You want to suppose change in conditions in visitation rights, that you can always do. But that has to be considered by the court which allowed it. I can give you an example. Many a time the mother, after filing of the visitation right, allowing the visitation right is allowed in favor of the father. The mother may seek alteration. It happens. So that way you can file.
So then,
which is referred to in internal page 5 of the order. Page 60. The following are the observations of the court. So far as another petition is concerned, to make visitation right by this court. Regarding this court, for the present, has no scope to entertain, has no scope to enter into the claims and assertions of the parties before the trial court regarding interim custody, visitation rights, contact rights. The trial court shall proceed in accordance with law. It can only be clarified that the parties to the litigation shall have the full liberty of adducing their respective evidence. Adduce the respective evidence, full liberty to complete their pleadings. Then, adduce their respective evidence. And also have an opportunity to argue the questions of law in the context of the facts of the case. Airtel को जो मांगी चलती
sir, so that was primarily to elicit the truth that the mother is not staying in Bhubaneswar.
ସେଟା ଆପଣ again the problem ହେଉଛି ଯେ ଆପଣ କଣ କରୁଛନ୍ତି କୋର୍ଟରେ ଜାଣି ପାରୁନାହାନ୍ତି ଜଣଙ୍କର ମୋବାଇଲ ଲୋକେସନ ଡାଟା is regulated by a particular statute.
Yes.
Civil court cannot do that in a custody application.
Yes.
So for that you have to study. So suppose now I have to say that the court has done the right thing.
Yes. I'm not requesting
Yes.
any.
Regarding the next petition, regarding the fifth petition, the Lord Judge Family Court -2 has observed thus. So let's say page 50-60 third paragraph. So far as the another petition is concerned to make you stands rejected. It is very fairly submitted by the petitioner appearing in person that she doesn't have anything to submit regarding the said petition, and the matter is put to rest.
Sir, I have one more prayer.
Just one second. I'm going to the next one. I have to go because these are the petitions are not numbered, or I have to locate them. So that is how I'm going through. The sixth petition has been allowed. Order has been passed.
Yes,
You turn to page 61 of your brief.
Yes.
So far as another petition is concerned, because the family judge has the same difficulties referring it to this petition, that petition, another petition. So far as another petition is concerned, kindly read that.
So far as another petition is concerned, the petitioner prays to pass necessary orders restraining the respondent to move the minor son, Master Pushan, out of Bhubaneswar without the leave of the court and his knowledge. The respondent filed objections stating that there is no bar to take the child from one place to another for occasionally. for a change occasionally. The minor son is facing difficulty in speech, so some doctors and therapists suggested to change place and surrounding of the son occasionally for a few days for visiting some tourist place, and for the purpose of the respondent mother, being a caring and responsible parent, used to take her son on certain trips. Admittedly, this proceeding is pending before the court for deciding the custody of child, Master Kushan Patnaik, who is under the care and custody of the respondent mother. The court, by order 2809/2002, directed the respondent mother not to restrain the petitioner in exercising his visitation right and conversation through VC. In such fact and circumstances, removal of the child from the jurisdiction of the court ought to be brought to the notice of the court, and obviously to the knowledge of the petitioner, who is the father of the.
So it has been allowed.
Yes, sir, it has been allowed. Sir,
Regarding the sixth petition, the Lord Judge Family Court has observed. Admittedly, likhibe, so that page 61, internal page 6 of the judgment. The order jaha comma page 61 of the running page 61 of the petition. The Lord Court has observed, Judge Family Court has observed. Admittedly, the comma, this proceeding is pending before this court for deciding the constitutional making. Petitioner who is father of the child. The respondent mother is not authorized. This petition is disposed of with the aforesaid observation. Page 62 is observation. Still further positive direction is there. He is not to be shifted and all this.
Yes, sir.
Yes, sir. So accordingly, the petitioner has no grievance as far as the state order in context of the petition he had filed before the Lord Judge Family Court as to.
Sir,
Yes.
just one thing. Sir, in the family court, I had filed an application to give me information from the school directly, because the mother is not giving me any information related to the child's progress and the extent to which ADSD.
No, one thing, Mr. Patnaik.
Yes.
They are again, you are complicating the things. Family court will not entertain a claim against the school.
No, I'm not
School
saying.
may be now you file a suit against the school about right to information something. When your child is studying in a school,
I will not file.
don't engage anything as far as school is concerned.
Yes, sir.
Because there is no reason.
Yes, sir.
Because school is a school, it remains a school.
Yes.
So if you want any information, they will provide you.
Sir, then
They will provide you.
I would just.
But the problem is that in my days, my parents never accompanied me to school. So you must understand. But I have changed.
Yes, sir.
We interfere so much in our child's education.
Sir.
So correct. I mean, you can't find there is a paradigm shift.
Yes, sir.
जुगादर्शरे परिवर्तन ହେଇଛି. So ସେଥିରେ ଆପଣ ସ୍କୁଲ କୁ ଏଥିରେ entangle କରନ୍ତୁନି କାହିଁକି? No, that reason କଣ? Can you guess it? Why I'm saying?
Sir, because it will have an adverse. It may have an adverse effect on the child. That ki
No.
school purta bapa dekla amandane case pok.
ସେଇଟା ଚାଇଲ୍ଡ ଉପରେ ନ ହେଇ ବି ପାରେ, ବଟ୍ ଆପଣ ଯେତେବେଳେ ଜଣେ ଟିଚର ହୁଅନ୍ତୁ ବା ଆଡମିନିଷ୍ଟ୍ରେଟର ହୁଅନ୍ତୁ, they will be unnecessarily feeling bad about the situation ଯେ ଇଏ ପିଲା ପାଇଁ ଆମେ ହଇରାଣ ହଉଛୁ.
ଆଜ୍ଞା.
ତାପରେ ଆପଣ it may have or may not have that we cannot say, but ସେଇଟା ଆପଣ କାହିଁକି ସେଇଟା ତ school is not an adversary. Why I said that you are not filed, we have not filed a case against the school.
Yes, sir.
The reason being school is not an adversary.
Yes, sir. I totally bow down to
So
this.
ସେଇଥିପାଇଁ I gave you the example. ଯେ ଆମର କଣ ଟିଚର କୁ କହିଦଉଥିଲେ ପ୍ୟାରେଣ୍ଟ ଯେ ଆପଣ ତାର ଆଡମିସନ କରିଦେବେ ସେ ଯିବ. So why this approach? I mean that has resulted no difficulty for any child actually.
Sir,
Those days are maybe your earlier generation. You can talk to your parents.
Yes, sir.
ତାଙ୍କ generation ରେ ସେମାନେ teachers were everything.
Yes, sir.
Teacher was told कि ଆପଣ ତାର admission କରିଦେବେ, and especially for working parents, they were not available during office hours, school hours.
Sir, I bow
They are
down,
not
sir.
available. So more कहया କଥା, it is not. We are discussing not the case. Please don't understand that. Please don't take it that way. I am simply saying it is advice. ଆପଣ school ସାଙ୍ଗରେ ଭଲରେ ରୁହନ୍ତୁ. School has basically, I mean there is no school much less KIT International or DAV or Sai International, they will be antagonistic towards parents. But don't create a situation where unnecessarily the school feels bad that ଆମେ ଆଙ୍କ ପିଲାଙ୍କୁ ପାଠରେ admission କଲୁ ବୋଲି ଅଯଥାରେ ଆମକୁ ଇଏ କରୁଛନ୍ତି।
Sir, I
ତ
am
ସେଇଟା
not
କାହିଁକି
at
କରିବ?
all, no, I am not at all against this.
ତେଣୁ ଆପଣ ଆଉ ଗୋଟେ ଜିନିଷ ଆପଣ ଯୋଉଥିରେ there is a possibility ମୁଁ ଆଜି ସକାଳେ in fact I start the day with in a lighter way. I was asking Mr. Swarup that why the parents are not accompanying the child to school. He remained mum. So then I answered that perhaps the school, it is better the child should go in the bus so that he reaches the school. If he is accompanied, the child is accompanied by father and mother, throughout the day they will be having their discussions and their issues. Child will be unable to reach the school. So it was but it is also partly in serious. Why partly in serious? Because when you are having your issues, differences, I mean, I am not finding any fault with anyone because I am not adjudicating. I am not judging. As far as your matrimonial case is concerned, now you have come to this court regarding admission of the child. So largely when the child is concerned, both of you have to forget everything. Your individual differences, maybe what you are saying is correct and what she did is not right. At least I will not say it is right. Not as a judge, but as a human being, that she is not intimating regarding the child's progress or not talking. But it is better you avoid those situations.
Sir,
regarding the child, you get directly involved, you go to school.
Sir, that is where the challenge is. When I'm going to the school, I have also filed an additional affidavit on 2 days before this, stating that when I went to kids' school, upon the direction from from the wife, that the kid people said that, sir, we have been strictly instructed by Miss Shalini Mahanti and her mother that we cannot give any information to you. So
ସେଇଟା ଆପଣଙ୍କର କିଛି କରିହବନି ସେଥିରେ ହାଇକୋର୍ଟ କିଛି କରିପାରିବେନି ଟ୍ରାଏଲ କୋର୍ଟ କିଛି କରିପାରିବେନି କିଛି କରିହବନି
sir I can state an example from an
you have to I don't know I mean that suppose again the problem is that
sir
if I mean unwittingly we rope in the school into the picture that doesn't augur well for the child.
Sir, my only request is that if you can send a order that he should not be restrained from getting information, and I can show you that other high courts are giving such type of orders in cases where
you read those cases.
Yes, sir, I have brought that.
No, you read, but I am not impressed.
No, I understand, sir. So I am just requesting that maybe a small order can be passed that
because you see, I mean, no two persons are equal.
I understand.
So I will be operating at my level and standard.
Yes, sir.
So and the reasons before you said that other high courts have passed such orders.
Yes, sir.
It is a coincidence that I told you the reason that why I will not enter the school.
I am just saying that just like in the previous order, you had said that KIT International School is requested.
I can very well observe that those are beyond scope of the present adjudication.
So,
I cannot pass a order against a school which is not party before.
It is
you
not
must understand
against the school. You
must understand it is not a PIL.
No,
suppose a PIL is filed, you have to understand the law. The problem is that you are not a student of law. Suppose because I have to presume that. I have to presume that KIT International School is not allowing the parent. So I don't know.
No, sir, I am saying that, sir, just hear me for a minute. Sir, in a case of, sir, just give me a second. I'll just tell the exact case details. Sama Adil versus, sir, 1 minute, sir. I think I misplaced it. Sir, just give me 1 minute. Okay. So I would request Karnataka High Court se case naata hochi Noor Ali versus Sada Adil writ petition 1. Sir, I have filed it yesterday in the court only.
The memo file karantuni. The petitioner has filed memo section enclosing emails. Which is on perusal of the said memo and the contents. Apparently, those have no relevance as far as the present adjudication is concerned. The section should not accept documents without being supported by affidavit. The matter shall be placed before the registered judicial to instruct the concerned section.
So give me a second. I will just find the exact para where it is written. Yeah, sir. Last page of this said order, Noor Ali versus Mrs. Sama Adil on February 20, 2025. Para, it is made clear. Last page, page 11. It is made clear that the school, that is Dean's Academy, presently the child is attending to, shall communicate all information with regard to child's report card, parent-teacher meeting to the father on a monthly basis, inviting the father to the parent-teacher meeting if it is physically conducted.
Para 8 ta padon.
Para 8 ko. Sir, 1 minute. It is also para 8.
Sorry, para 8 आपण जोटा आरता फाइल करचंती.
Again.
Prakash D Naik, Bombay.
Prakash.
Gayatri.
Gayatri. Okay. Okay.
Versus Ame Dilip Sardesai.
Yes, sir. In that we can proceed with
Ame, sir, that should be. So can you read para 8?
Yes, sir. 1 minute, sir. Mr. Rao, appearing for the partner of father, submitted that the father is concerned for the welfare of the child. Father cannot be deprived of the visitation right to the child and is also entitled for overnight custody.
So this was the context of the application. So that situation has not arisen here.
Sir,
you must understand that.
Sir,
so your visitation right, if you look at order dated order internal page 6, page 60.
Yes, sir.
Look, read it again.
Sir, the family court upheld the order that it was passed, that was passed on 28/9/2022. That
not
is
upheld.
Upheld मतलब जो order था दिया है.
So that visitation order is there. But what the Bombay High Court Goa bench was considering was a case where the visitation right is denied. Now come to Noor Ali.
Sorry?
Noor Ali question.
Yes, sir.
अगर ये प्रॉब्लम अबाउट लिवर सो नॉन पर्टिकुलर इन फाइलिंग आपण गोटे मेमो फाइल करछोनी तार ना इंडेक्स अछि ना पेज अछि.
Sir,
नूर अली फाइलिंग.
Yes, sir. I have requested to go to the last
नूर अली
page.
ना पेज 3 को जान.
Yes, sir. Yes, sir.
para 4 पढो.
When such being the case, on hearing both parties, learned two additional civil judge, Bengaluru Rural District, Bengaluru rejected all the applications.
Now can you kindly read para 3?
Yes, sir. The father filed an IA number 5 seeking the following player.
4, Roman 4. Okay.
I read that.
Then kindly read para 3.1.
Para 3.1, the father filed an IA number V5.
Okay. So then kindly read 3.2.
The mother filed an IA number 6 seeking the following.
So the High Court was adjudicating after the petitions were, all the petitions were rejected. You
No,
must
sir,
understand that.
the case, sir, since I am aware of this particular case, I know that the family court has not taken the final decision on with whom the custody will remain.
I cannot go by personal knowledge. Suppose I know so many things about you.
Okay.
So first you have to go by the order itself.
Yes, sir.
Now you will say that the High Court order is not properly structured. So you must understand what you are arguing.
Yes, sir. Sir, I am saying that the writ petition in this.
So now if you now kindly come to the again go back to the petition, the order. Page internal page 2, page 57.
Page in my case, okay. The first yes, sir. Page 57.
Yes.
This order arises out of the number of petitions filed.
Kindly read 58. You have to be fast also.
Yes, sir.
For page mark nahi, tapare 58 dekho.
On perusal-
Admittedly, read admitted. Flip line.
Admittedly, protection of the interest of the child is paramount consideration. Both parents have equal right to decide the future study prospect of their child. In the present fact of the case, original CP 632 of 2000 is pending for decision regarding the custody of the child of both the parties. Now the child is under the care and custody of the respondent mother. Today, the respondent appeared in the court with the child master possession who appears to be healthy state. But the respondent submitted that her child is not suffering from autism problem, rather he is suffering from mild ADHD. The master Pushan Patnaik has not completed 6 years of age and his admission in the school. For his admission in the school, the petition reveals that he is admitted in a preschool.
So now you understand.
Yes,
You understand the difference between Noor and your case.
Sir, in currently my son.
Fact.
Yes, sir. My son was studying in preschool.
You cannot be a predictive path that no wrong will be committed to you. I can't assure you that. Because you'll see that just give you example.
Yes, sir.
Though it may sound very silly. Which law prohibits committing a crime? So you must understand. So law says that if somebody commits a crime, he will be punished. Prohibition is not there in any law. Such and such crime is rather prohibition is that don't walk in the right side of wrong lane. Don't cross the traffic light. That is kind of a prohibition. Even in certain cases, particular dress one has to wear and all these things regulating human behavior. So your case and Noor's case are completely different. Noor's case, after the admission takes place, now you may keep international school will be very bad towards you. That finding has to come before the trial court. You please understand that. So that is how I have to explain you by, in fact, because what the facts are before the trial court and out of which this case arises, it cannot be, I mean, what you call it, it can be, I mean, the time cannot be reset.
No, sir, I
totally bow down, sir. So you may be apprehensive that the kids' school will be behaving badly with you.
Sir, I am just saying that I had already informed this court with the help of an additional affidavit regarding the.
No, this court, the additional is the memo dated 6/4/2026.
Sir, I had filed an additional affidavit.
Is rejected, being not in proper order, not supported by any affidavit. It has also to be noticed that the memo doesn't refer to any part of the petition that is pending before this court. Yes.
Sir,
affidavit
Sir, additional affidavit which I had filed on the date of 26/02/2026.
Yes.
Sir, there, if you go to the para number, just give me a second. Para number 5 to 8.
Yes.
The opposite party who is staying in Gurgaon initially avoided to reply and upon further reminder.
That's besides the issue.
Yeah.
That is besides the issue.
My point is, upon further inquiry about the admission coordinator informed me the child has visited the school and they have been strictly instructed by the mother of the child not to share any information regarding the school.
So after they do that, you approach the court wherever or you do whatever you like, but not before this court.
Sir, but this was.
So that is how I had to make you read Noor. You read Noor again, that paragraph 4. Noor internal page 3.
Sir, just give me a second. Paragraph 4. When such being the case, on hearing both parties, learned to additional civil judge Bangalore Rural District, Bangalore, rejected all the applications.
So kindly look at the top of the page.
These writ petitions are filed by the father and the mother of a minor child.
That is this plural. All the applications were rejected, 4, 5, 6. So thereafter they approached. In your case, suppose the international school, because you see, we must understand, I have already recorded that the child has taken admission on, I had passed the order on 12/3.
Yes, sir.
Child has taken admission on 7/3.
Yes, sir.
So those things are yet to happen, we do not know. And it is for you to decide whatever you like.
Yes, sir.
Nobody can restrain you.
Yes, sir.
So, so that is how the general advice that don't entangle the school into all these things. Let the child have a future.
Sir, I'm not saying that I'm trying to entangle the school. I'm just trying to get information from this school.
Sir, when don't put the cart before the horse. ଆପଣ ଯେତେବେଳେ ସ୍କୁଲକୁ ଯିବେ ଆପଣଙ୍କର after your the petitioner expresses anxiety that he will not be provided any information by the Skit International School where the child has taken admission as indicated today before the court on 6/3 on 7/3/2024 7/3/2026. At this stage, such an eventuality cannot be predicted as apprehended by the petitioner. There is no reason the school will behave differently with father of a child and mother of a child as is presumed imagined by the petitioner.
Sir, they have always done that in.
Sir, 5-3 sir, when did you have the opportunity to interact with the school?
For the admission.
When? 7/3, after 7/3, then again go back to Noor.
Sir, I would request one thing here.
You please again please read 3.1. Noor, para page 3.
Yes, sir. Just give me one. Para 3.1, the father filed IF4.
Slowly so that it registered.
Yes, sir. The father filed IA number 5 seeking the following pair. XXX to direct the minor's child school to be changed from the current institution, Dean Academy,
Whitefield,
to Greenwood High International School, Sarjapur Road, or in the alternative to any other neutral school as prayed for the in the
so
affidavit.
those things were rejected, then they came to the High Court, then things evolved. But at least in your case, saving grace for the child is that he has taken admission,
yes,
and it is not subject matter.
Okay.
Now, whether he will study in KIT International or Dean's Academy or Greenwood High International School, Saraspoor. So the facts are completely different. There is a very 1901. There is a decision of Lord Halsbury.
So I would request
as a student of law, one must read that. This case, when you are thinking that this is the law, that is not the law because the case decided what it is on record.
Sir, sir, but the mother is restricting me to go to the school.
Laws and affair. I cannot adjudicate your apprehension.
No, sir.
You must understand.
It is in the written email.
Whatever is happening, so that is what I have observed. I have already passed orders that there is no reason to be apprehensive and speculative.
No, sir. May I please submit the
after the child has taken admission on 7/3, the mother has restrained you,
yes,
and repeatedly you are saying that she is not staying here.
Yes, sir.
All India law report study थी लगे, फिराई लीची, ठीक है सर, और वाला चीज़, दिलाई all India law reports. Yes.
I want to refer to page 43, this petition.
The petition.
And wherein that is the visitation right decided by Learned Family Course. Page 43. Paragraph. Each
अपना child को 6टा बेले तार से speech therapy में छाड़ दियो.
Sir, sir,
ଆପଣ ଯୋଉ 6ଟା 15 କହୁଛନ୍ତି 6ଟା ବେଳେ 15 ମିନିଟ୍ କମେଇ ଦିଅନ୍ତୁ।
sir, I have one thing to submit before the court. They said the speech therapist come at 6:30. I go to their house.
ସେ 6 ରୁ 6:30 କୋର୍ଟ ଟାଇମ୍। କୋର୍ଟ ଚାହୁଁଛନ୍ତି 6 ପରେ ତାର ପାସ୍ ଟାଇମ୍ ସରିଯିବ।
Sir,
The child regarding the ଆପଣ ଆଇଏ କଣ ଦରକାର? ସେ ଆପଣ କୋଉ ଅର୍ଡରଟା ଚାହୁଁଛନ୍ତି କହୁଥିଲେ ମଡିଫିକେସନ ରେ?
ଆଜ୍ଞା ମୁଁ ଏଇଟା ଦେଖିଦେଲେ
12(3)
କ୍ଲାରିଫାଇ ହେଇଯିବ ଟିକେ। ସେ ଯୋଉ ପେଜ 43 ରେ ଆଜ୍ଞା ଫ୍ୟାମିଲି କୋର୍ଟ ଅର୍ଡରଟାରେ ଜିନିଷଟା ଅଛି ସେ ଟିକେ ପଢିଦେବି।
ନାଇଁ ଆପଣ କେତେବେଳେ ଚାହୁଁଛନ୍ତି ସେ ପାର୍କ? ଆପଣ 6ଟା ବେଳେ ହେଲେ ହବ ତ କୋର୍ଟ?
ନାଇଁ ଆଜ୍ଞା ମୁଁ କହୁଛି କି ଛୁଆ 4ଟା ବେଳେ ସ୍କୁଲରୁ ଫେରୁଛି।
ହଁ।
After the school he returns to home at 4:30 p.m. So from 4:30 p.m. to 6 p.m. he stays at home, he takes his snacks and gets refreshed. And if in that period he again goes to play, then he does
ସେଟା ହେଇପାରିବ। ଆପଣ ବଗିଚାରେ ଖୁଆନ୍ତୁନି। ହେଇପାରିବ।
just I am referring to the order of family court.
ସେଟା ମଡିଫାଇ ହେଇଗଲା।
ଆଜ୍ଞା
ମୁଁ ତ ଫ୍ୟାମିଲି କୋର୍ଟ ଉପରେ ଅଛି ନା।
ନା ନା ମୁଁ
ସେଟା ମଡିଫାଇ ହେଇଗଲା। It is stated by the Lord Counsel for the opposite party that the child returns from school at 4:30 p.m. in school bus.
Yes.
School bus. He's taken for playing at park as directed by observed by order dated 12/3/2025
26.
12/3/26 para 7 my lord. Para 7 page
Para
3.
Para 7 and 8 of the said order is reproduced.
My lord.
Para 7
starts in
so the child should be taken to an open space for which the petitioner and the opposite party are directed to agree. It should be at their option for both of them to remain present. However, at least one of them should remain present. Seti kar debe. Para 7 ta reproduce kar debe. It is submitted by the Lord Counsel for the opposite party referring to IA number 6447 of 2026 that the child cannot go to play at 4:30 p.m. The such prayer is rejected. The mother shall arrange the opposite party mother shall arrange for feeding the child, and at 4:30 itself at her place or at the park, the child shall play till 6 p.m. if he likes, or earlier.
Sir,
The child shall not be compelled by the petitioner or the opposite party to stay in the park more than the child wishes.
Sir.
After the child returns to home at 6 p.m., he shall follow his routine of speech therapy. If that happens as stated in the IA number 6447 of 2026, filed on 6/4/2026. The parties shall approach in view of the above detailed discussions.
Sir,
Regarding the order passed by the learned judge family court.
Sir,
Nothing survives further in the present application.
sir, I have one.
The learned judge family court too shall proceed in the matter in accordance with law.
Sir, I have
Yes.
one. Sir, we can take extra time.
No. For any condition, you have to. I cannot become the family judge. You must understand.
My lord, refer to page 43.
Yes, 43.
Wherein the order follows.
The above order regarding visitation of the father is in addition to the order dated. Who order grant it na?
28/09/2022.
28/9/22.
Page
In
39.
addition, this order shall no way affect the operation of the said order and is only supplemental to the arrangement.
My
Sir,
yes,
page 43 କଣ yes please.
permitted to praise.
ସେ କଣ କହୁଥିଲେ ଗୋଟେ କଣ ତାଙ୍କ ଶୁଣିବେ yes
Sir,
Mr. Patnaik କଣ
Sir,
କହୁଥିଲେ
like you so like the court mentioned that this order is supplementary to the order of the 2809/2022. Sir, my challenge is that I was given 6 hours of visitation, 2 hours each, but in the weekdays, maximum 1 hour is only possible. So I am requesting that on the, as per my discussion with the opposite party mother who is actually taking care of the child, they have only suggested that Saturday you come in the afternoon.
you filed that application you agree before the trial court
Sir,
the parties shall have the liberty to agree for any
Sir.
any arrangements
Sir, my
if
only,
they do so
sir,
and inform the court
sir,
what would be convenient
sir,
to both the parties regarding the vegetation, contact, rights of the father.
sir, my
The court shall have. The court shall take up the matter to decide the matter. The court shall pass appropriate orders in its discretion, looking to the welfare of the child.
Sir, my only challenge is that if vegetation is getting reduced because of the school timing, at least this court within its direction.
No, this court cannot direct reduction of vegetation during school time also. You must understand. So whatever adjustments if you agree, then you approach the court for any kind of modification. That have the last line is that only.
My lord, if I refer to page 43.
43 yes.
The second paragraph starts as
From the above discussion.
from the above discussion.
For the above discussion.
For the above discussion, the petitioner husband is allowed to meet his minor child twice in every week for 2 hours only at a suitable time at the parental place of the respondent wife.
But the thing is that again, Mr. You must not make mistake like the petitioner is made. This is in the context when the child was not admitted to any school.
Yes, my lord.
So now suppose in the ପଢନ୍ତୁ ସେଟା ସେ ଶୁଣିଲେ କି ନେତା ପୂର୍ବରୁ ସ୍ଲୋଲି ପଢ ଟିକେ ବଡ ପାଠ କୋର୍ଟ କରିଦିଅନ୍ତୁ inform the Lord Judge family court. Family court 2 that had passed the order of vegetation. That has said. So now 43, if you say that since it is every day to 1 week, so it cannot be, it's not possible. To once the child gets admission, the court shall also take note of the fact that the child was in play school, preschool, when the order was passed. Occasional bicycle. Much water has flowed in all the rivers in and around Bhubaneswar. At least the child has been, the child is, the child is now got admitted to IT International School for his studies. His school hours would be a factor for consideration regarding the child's welfare.
Since that order of visiting park or open space is in addition to this, so that is 1.5 hours. This is 2 hours. How this will be?
ଆପଣ ସେ ଘଣ୍ଟା ହିସାବ କଲେ ବର୍ତ୍ତମାନ ଆଉ ଗୋଟେ ଇଣ୍ଟରେଷ୍ଟିଂ ଆସ୍ପେକ୍ଟ ଥିଲା ସେଟା କରନ୍ତୁ ନା I can give you, I am seeing people how they are. ଆପଣ 30 ଦିନ କହୁଛନ୍ତି 30 ଦିନ 720 ଘଣ୍ଟା ଆପଣ ପାଖରେ ଛୁଆ ରହିଲା 720 ରୁ ଆପଣ କେତେ ଘଣ୍ଟା ଛୁଆକୁ ଛାଡୁଛନ୍ତି 6 ଘଣ୍ଟା କି 12 ଘଣ୍ଟା does it make a difference? ଆପଣ ଯୋଉ ହିସାବ କରୁନାହାନ୍ତି ଟଙ୍କା ଭଳିଆ ସେଟା କଣ ଆୱାରଟା ହିସାବ କରାଯାଏ?
ନାଇଁ, my submission is since child's class tuition.
ଆପଣଙ୍କର you say that you are having the custody of the child or not? Yes, then it is 24/7.
No, my lord,
ସେ ସ୍କୁଲରେ ରହିଲା କି ତାଙ୍କର କୋଉଠି ପ୍ଲେ ସ୍କୁଲରେ ରହିଲା, it is not important.
ମୁଁ ସେଇଟା କହୁନି ମୁଁ କହୁଛି ସିରିୟସ୍
ତାଙ୍କର ଅଧିକା ହେଇଗଲା ତ ଭିଜିଟେସନ କଣ୍ଟ୍ରାକ୍ଟ ଅଧିକା ହେଇଯାଉଛି।
ନାଇଁ ସେ କଥା କହୁନି ଏଟା ଇମ୍ପ୍ଲିକେଟ ମାନେ 4.5 ଯଦି ସେ 6ଟା ନେବେ ତାପରେ 2 ଘଣ୍ଟା କେତେବେଳେ ସେଟା ମ୍ୟାନେଜ ହବ କାହିଁକି 2 ଘଣ୍ଟା ସମୟ ନାହିଁ 6ଟା ଟ୍ୟୁସନ ଯିବ since my lord has directed it, this will be in addition to this order.
No, no,
Visitation.
no.
Yes, sir.
ନାଇଁ
It was dictated.
ଆପଣଙ୍କର ସେଟା ପଢନ୍ତୁ ଆଉ ଆପଣଙ୍କର ଏଭରିଡେ କଣ୍ଟାକ୍ଟ ରେଟ୍ ଥିଲା ନା କଣ ଥିଲା କୋଉ ଜାଗାରେ ଥିଲା?
ସପ୍ତାହକୁ 3 ଦିନ ଏମିତି ସେ ତୁମ ପଢୁଥିଲି ସେ order from the above discussion for the above discussion petitioner husband is allowed to meet
କୋଉ ଜାଗାରେ ପଢୁଛନ୍ତି?
43 second paragraph.
ଆଚ୍ଛା
Meet for the above discussion, the petitioner husband is allowed to meet his minor son thrice in every week for 2 hours.
Since the father is now getting chance to meet the child every day on school days,
Sir,
at 4:30 from 4:30 p.m.
sir,
to 6 p.m.
हुआ आसो नहीं सर
ପାଞ୍ଚଟାରୁ ଛଅଟା
हाँ sir.
5ଟାରୁ 6ଟା from 5 p.m. 4:30 to 5ଟା ଖାଇବେ 4:30 ସେଟା ଠିକ ଅଛି that I'll just if the order requires repair this kind of court proceeding actually now getting that everyday time from 5 to 6 to meet the child, which is much more than the 2 hours per week.
Thrice every week.
2 hours thrice a week. The earlier direction of the direction of the Lord Judge Family Court 2 hours thrice a week merges with the present order.
Sir, I have
and no further.
Sir,
then either you have the Lord the petitioner objects for granting him visitation rights every working day for 1 hour.
Sir,
so accordingly,
sir,
he shall have 2 hours thrice a week and not every day.
Sir,
from 5 to 6.
Sir,
this cannot continue.
Sir, 1 minute, sir.
Sir, this is not by folding hands. You can't improve your conduct.
No, sir.
Sir, what you have said, I have recorded.
Sir, just hear me out, sir. Sir, it is also a
By
fact.
saying that, sir, hear me out. With folded hands, it is submitted by the petitioner.
Sir,
yes.
Sir, give me 1 minute, sir. Sir, for 2 years.
And saying that, give me 1 minute. It is submitted by the petitioner.
Sir, my only submission is that for people having ADHD.
recording problem. Exact produce kar diya.
Yes, sir. Sir, my only submission is that I was initially granted 6 hours of visitation 3 times a week. But that order was difficult to follow because the mother had left the child.
Sir, you file whatever you want. I am not the trial court to modify.
Sir,
if you want modification, file it before that.
Sir,
I have modified, granted you every day 1 hour. If you like or you do not like, that's up to you.
Sir,
if you do not want, you continue with the earlier order.
Sir, then I'm okay with this.
Since the petitioner is not, no, because you can't bargain.
No, sir,
you can't bargain.
I'm not bargaining.
When this court observed that the petitioner has to decide whether he wants to continue with the direction of the Learned Judge Family Court, having visitation 2 hours twice a week, or one hour every day on school days, as directed in view of the admission of the child to the school. Initially, he was saying that I have objection in court. Subsequently, he states that he will have visitation 1 hour every day after the school hours from 5 to 6 on school days.
Sir, can you, I am just requesting this court that for the weekends when the child is relatively free.
That you can't, that you must not always. Again, you understand English, sir. आपण जो टाळे बसଛନ୍ତି ତ काहे हाडुଛନ୍ତି से स्टेज आसीनी आपणଙ୍କ ପାଇଁ ଆପଣ कोन डिसाइड करिवे कोर्ट वेट करंतु
Sir, my only submission here is that in the interest of the child,
The,
if the
the
order
case
is
is relied upon. The नूर बेटा करते हैं नूर गोटे आ गोटे होची से ये अमय सरदेसाई नूर and अमय सरदेसाई बेटा are clearly distinguishable on facts. In case of Noor, the parents of the child both filed applications before the trial court seeking interim custody, transfer of the child from one school to another, which were rejected. In the present case, the child was yet to take admission to standard. Now he has taken admission to standard 1 only on 7/3/2024 during pendency of the petition. Therefore, the reliance of the petitioner on the said decision is of no avail.
Sir.
Perusal of the judgment rendered in Amay Sardesai. Paragraph 8 indicates that the writ application was in the context of completely different facts. As the lauded district judge rejected the prayer for interim relief by order dated, had rejected the prayer for interim relief. In the present case, as has been observed by the lauded Judge Family Court 2, order को पेज आरंभ हो जाता देखिए 25 ना
57. 57, sir.
Eleven 4/2025 रे लिखिए hard on the petition dated 7/3/24 and 11/2/2025 page 55 रे अछि. Each of the petitions contains several prayers. The court करते हैं. তারপরে 952025 page 57. Quote, the petitioner also admitted during hearing of the petitions, except once, he has never paid money for the treatment or study of the child, but he expresses his desire, the page 59 archive, to bear all the expenses.
So I have already filed an application regarding that, and the family court has already proceeded on that. They have already, I am paying for the past the payments that past expenses that the mother had incurred, and I'm also paying.
ଆପଣ ସେଠି ଏଠି appear କଲା ବେଳେ ସେଇଟା ମୁଁ actually ତାକୁ quote କରୁଛି. I am not deciding that.
Okay.
You are not before the family court.
Yes, sir.
Yes, the petition starts disposed of. The proceeding continued for 2 hours, from 2:30 to 2 hours